What is not okay if it is touching an area which is dirty and is not cleaned prior to being used again.
If they are not aware that they're touching the ground, is it your belief that they are going to be aware if they happen to touch some evidence?
Sustained. Cause for speculation.
Mr. Matheson, I want to ask you some questions about the blanket. Do you have that in mind?
Yes.
You believe that it is a proper procedure at a crime scene where you're collecting biological evidence to bring something from outside the crime scene, such as a blanket, and put it on the evidence?
No, I do not.
And the reason that's inappropriate is because you can inject trace evidence that wasn't in the crime scene into the crime scene by doing that, correct?
That's possible, yes.
And a blanket such as a thermal blanket is an excellent collector of trace evidence, is it not?
Improper hypothetical.
Well, we're assuming facts that aren't in evidence.
Would you say a blanket is a good collector of trace evidence?
Vague and calls for speculation.
Overruled.
I would say that yes, a blanket has a very good chance of picking up trace evidence.
And if a blanket is thrown out over a scene, it has a potential of depositing that trace evidence on the scene, correct?
Improper hypothetical assumes facts not in evidence.
Overruled.
If the blanket is taken and thrown out or shaken out or something like that, that would allow what was on it to be spread out throughout the scene, and that was to land on something, you have the possibility of contamination.
How about if it was just put down on something? Trace evidence could come off of it, couldn't it?
If it was carefully laid down, you have the potential of something falling off of it directly under it, yes.
Should your criminalist be alert to foreign things, such as a blanket being brought into a crime scene in terms of their processing of that scene?
Argumentative, vague, irrelevant.
I would think that that's something that you should be aware of, that it's occurring.
So that's something they should check on, correct?
Well, it's something that is present that you should be aware of, yes.
Do you know whether Dennis Fung ever made any inquiry, or Andrea Mazzola ever made any inquiry as to where that blanket came from?
Argumentative, no personal knowledge.
Sustained. Those people have already testified.
I'm sorry?
Sustained. Let's move on.
Would you expect a competent criminalist to make some kind of inquiry as to where a blanket in the middle of the crime scene came from?
I think that that would be an appropriate question to ask.
Would you expect a capable, competent criminalist seeing a blanket in the middle of a crime scene with blood on it to collect that?
It's an incomplete hypothetical.
Overruled.
I can speak for myself at this point. If I arrived at a scene where a blanket was heavily covered with blood and was advised that that was over the victim, I would not necessarily collect it.
To your knowledge, is there any forensic reason or legitimate forensic or investigative reason for putting a blanket on a body at a crime scene?
From a forensic standpoint,
Yes.
there is no reason.
Now, do we have the board that was shown yesterday with 107 on it?
Mr. Blazer, I need to change court reporters at 3, so perhaps this will be a good time to look for that.
Okay.
Mark. All right, ladies and gentlemen, we're going to take a brief recess for 10 minutes to change court reporters. Please remember all my admonitions to you. Have the jury just step back into the jury room, and Mr. Matheson, you can take a 10-minute break. All right, we've been rejoined by all the members of our jury panel. We have a fresh court reporter, Mr. Blazer.
Thank you, Your Honor. Mr. Matheson, are you aware in this case that Dennis Fung conducted a pheno test on the 3 pedals of the Bronco with the same swab? I'm sorry, was it Ms. Mazzola? Andrea Mazzola, sorry.
I have heard about it, yes.
Is that an acceptable procedure from your standpoint?
That is not how I'd do it, no.
That's unacceptable, correct?
That's correct.
And the reason being that you would not want to touch a second piece of evidence, potential piece of evidence, with an item which you've used to touch the first piece, correct?
It seems none evidence that it was evidence.
Overruled.
I try and limit the use of a swab to one particular item, that's correct, so you're not carrying it then over to another one.
Now, how are the criminalists that work for you trained in the use of phenotesting? Is there any specific course on that?
A specific course on that one item? No.
That's fairly easy to do, is it not?
Yes, it is.
And it's a fairly standard procedure to do?
Yes.
Using the same, we'll strike that. The criminalists have as many swabs as they need in their kits, do they not?
I don't know about as many. They do have available to them in the kit a packet or two. There should be some in the truck, and there's plenty back in the laboratory.
Well, do you know whether or not Dennis Fung had and Andrea Mazzola had extra swabs when they did that to the pedals of the car?
Speculation. Sustained.
Have you talked to them about that in terms of correcting their procedure?
No, I have not.
Now, I want to talk about packaging and unpackaging materials for purposes of DNA testing or preparation for DNA testing. Now, there's been considerable testimony about the use of plastic bags to transport blood samples. Are you aware of that?
Yes, I am.
Now, is it your understanding that it is appropriate to transport wet blood samples in plastic bags prior to booking?
Yes, it is.
What can happen to blood if it's kept in plastic while it's moist?
Well, the plastic doesn't allow any drying process to occur, so it stays moist. And like I mentioned before, a moisture or a damp environment leads towards degradation.
Would you agree that the proper procedure is after collection of a blood stain by using swatches, you should try to dry it as fast as possible or as soon as possible?
I believe it should be dried as soon as practically possible, yes.
And the crime scene truck that your criminalists use has a refrigerator in it, does not?
Yes, it does.
Now, you indicated on direct that refrigerator is used for chemicals and is not used for evidence samples. Did I hear that right?
As a rule, that's correct.
Is it available to use for evidence samples if a criminalist wants to use it?
Yes, they're not denied. We don't say don't put evidence in there.
Would storing evidence in plastic bags, wet blood stains, if they were put in that refrigerator, would that retard any degradation that might go on?
Yes, if you can lower the temperature at all, it helps slow the degradation process. It doesn't stop it.
Is there any standard period of time beyond which you should not keep wet blood stains sealed or in plastic bags?
I don't believe there's a fixed time frame. We suggest as soon as possible.
And is 7 hours acceptable?
It depends on the circumstances. I don't believe that's excessive. I would like, if it was possible, to get them back in the lab and dried before that.
About 7 hours in the back of a truck on a June day.
Still, I don't, if that's the condition in which they're working and that's how they had to be kept, I don't think that's unacceptable.
Have you done any studies to determine how fast blood degrades under those conditions?
No, I have not.
Have you read any literature? Are you familiar with any literature?
Specifically dampened plastic bags, no.
In your view, is it a bad practice to store wet blood stains for up to 7 hours in a van in the sun?
Like I said before, I don't think it's a bad practice. I would like it to be avoided if there's some practical way to do it. We want to get those dried as soon as possible, but as far as being a bad practice, no.
Now, you testified on direct about taking some fabric samples from the carpet in the Bronco. You recall that?
Yes, I do.
And the carpeting that you took that sample from had been cut out of the Bronco, had it not?
It's my understanding, yes.
Do you remember when you took that sample?
I believe that was on September 1st.
And where did you take that sample?
The carpeting at that time was in the serology unit.
How had it been moved from the Bronco to the serology unit?
Well, at some point it was cut out of the Bronco, transported back to the evidence processing room, where it was wrapped in white paper and stored in a box, along with a variety of other items. That box was at some point transported into the serology freezer and stayed there, I believe, until in January.
Did you see that item as it was unpackaged before you took your sample?
I believe so, yes.
That carpet had been rolled up as part of the collection process, had it not?
I believe it had been folded. I don't remember it being rolled.
Do you think that's an appropriate procedure to preserve possible blood stains on a carpet, to remove the carpet and then fold the carpet up?
If the blood stains were damp when that happened, so it could come in contact with another part of the material and thus transfer some of the pattern, no, I don't think that would be appropriate.
How about if it was dry so that it could flake off of the purported blood stain? You wouldn't want to do it then either, would you?
Well, as far as the pattern is concerned, I don't think it would affect that. You'd be losing a little bit maybe with the flaking. That flaking process that you were talking about could then distribute blood to other parts of that same item.
If there was other cellular material elsewhere on the carpet other than where the apparent blood stain is, that material could be transferred to the stain by folding the carpet up, could it not?
It could flake off and potentially come in contact with another stain, yes.
That is a bad procedure to use to preserve that kind of piece of evidence, isn't it?
It is not the best way. The evidence will still be there available to you. Probably the best way would be to sandwich it between two pieces of paper and then fold it if you had to.
You wouldn't do it the way it was done, would you?
I don't believe so, no.
Now, I want to talk about the drying process back at the evidence processing room. Your understanding that the wet swatches are taken from the plastic bags and placed into open test tubes.
That was my understanding of how it was done in this case, yes.
Now, have you done that yourself with samples?
No, that isn't how I dry them.
How do you dry samples?
After I get back from a crime scene, I have a coin envelope with the one or two plastic bags that are in it with the swatches. I take the plastic bags out, cut along one side, cut along the bottom so I can open it up, and then I lay the plastic bag with the swatch on it on top of the coin envelope that it came in and allow it to dry that way.
Do you feel that is a better procedure than the one that was used in this case?
No, I think either one works fine.
Now, when you take but have you tried it the way it was done in this case in some situations?
No, I have not.
When you take a wet swatch and try to put it in a test tube, would you agree that it is likely to stick to the sides near the top of the test tube?
Well, if it's damp when it's put in there and it comes in contact with it, yes, it might stick a little bit.
And doing that, it might also deposit some of the blood near the top of the test tube, correct?
It's possible, yes.
Now, when it is allowed to dry overnight in that condition, the next morning there is going to be dried blood in that test tube near the rim of the test tube, correct?
There could be, yes.
Now, when these items are stored, when they're put in the cabinet to dry, they are all set in the same cardboard box, one next to each other, correct?
No shown with personal knowledge.
Overruled.
Yes, they are.
The items from Rockingham were put in open test tubes in the same cardboard box as the items from Bundy, correct?
No shown with personal knowledge.
Overruled. Do you know?
Do you know?
If they were specifically put in the same box?
Yes.
No, I do not know.
When the swatches are removed in the morning, what's your understanding of the procedure that Dennis Fung and Andy Remazola used?
I don't specifically remember how they got them from the test tube into a paper bindle, but at some point they were transferred from the test tube, placed into the bindle folded, and placed in a coin envelope, and the test tube thrown away.
Would you, if you were doing this procedure, take pipettes and scrape the swatches out of the tubes?
Well, that seems like a valid way to do it.
And if you took a pipette and scraped a tube that had dried blood around the rim, would you agree that you are taking the chance that some of that blood might flake off and get on other things like your hand, your clothing, the table?
If you were not being careful and just took the pipette and ran it around the inside and scraped a lot of the area and then allowed it to flake off, I suppose you could make that happen.
And do you think that if that were to happen, if blood were to flake off, you would always be aware of it?
If you are being so sloppy as to handle it as roughly as scraping the areas as opposed to just reaching in and flaking out the one little swatch, I suppose you could miss that.
And is that a good reason why, if you're going to use that method, you should change the paper on the table between each test tube?
Well, if you're not just randomly in there scraping around, if you're being careful with your pipette tip to just catch the swatch and flake a little bit of it out, I still don't see where it's necessary to constantly change the paper.
What about touching the rims of the test tubes with your gloves? Would you recommend that?
Improper hypothetic.
Overruled.
Oh, I think I'd tend to try and stay away from it, but if you're on the outside of the test tube and any sort of blood or residue is on the inside, you're not coming in contact with it, so it should not be a problem.
Is it a good procedure to take an item of evidence from one crime scene and take it to another crime scene if it has or could have biological material on it?
Complete hypothetical.
Overruled.
If that evidence is not brought in direct contact with the scene, if it's in packaging material or something like that, I don't see where that would be a problem.
If Detective Lang had asked you to bring the Rockingham glove for him to look at over the bodies at Bundy, would you have done it?
Misstates the evidence.
Sustained.
Is it a proper procedure, in your view, in this case, to take the Rockingham glove from the crime scene truck, take it in, step over the bodies so the detective can look at it?
If I was not standing directly over the bodies or directly over any evidence that was being collected, I would not have a problem with opening the bag up so you could see inside.
You don't have any problem with that?
No, the evidence is down inside of a closed container. I'm not taking it out, not working with it over the evidence area. It'd be preferable if I could get him out and away from the scene, but even taking it in under those conditions, I don't believe would be a problem.
Would you prefer that if the detective asked you to do that, that you'd say, no, let's do it over here by the truck?
Oh, sure, it'd be preferable to have him come out and step outside, but I still don't see where there would be a problem.
Now, if your criminalist is asked to do something like that, and they have a feeling that maybe this is not so smart, what should they do?
If they have a problem with something that's being requested of them from the detective, they should advise the detective of that.
They shouldn't just do what the detective tells them to do, should they?
No,
Overruled.
no, they shouldn't.
Now, you testified about control swatches being taken at the same time that swatches are taken from a bloodstain. You call that?
Near the same time, yes.
And the purpose of the control is to conduct the same kind of testing on the control as you do on the swatch in order to see whether you get some sort of positive result on the control, which would indicate something might be wrong with the test, correct?
It could indicate that there was potentially some problem with the sample, yes.
And if you had a failure of controls, would you agree that you should disregard the test results? Or perhaps do them again?
Sustain.
You understand what it means to have a control fail?
I'm not sure what you mean by failure.
You run tests on it and you get an indication that there's blood on it when you thought there was nothing on it.
Well, then the control, in a way, is serving its purpose. It's showing you that there's something there and alerting you to the fact that there's a potential problem.
Okay, in that situation, the control worked, and you should disregard the test.
As far as disregard, just throw it out and totally ignore it?
Do it again.
That's a potential, yes. You'd want to maybe look at your results and what was obtained.
Now, if you didn't take a control, what's your understanding as to the accepted scientific practice in the community of forensic scientists that do DNA testing about not using controls?
Which type of test?
Sustain.
Not collecting controls with bloodstains.
Question is unintelligible.
Overruled. Just regular blood stains, taking controls.
Well, you should, whenever possible, take a control nearby a blood stain that you collect.
And if you don't take a control, should you report a test result? What's your understanding of the accepted practice, or do you know?
Still vague as to which type of test.
I take it we're talking about conventional serology?
Well, let's talk about conventional serology and a DNA test.
No, one or the other.
Conventional serology.
In the case of conventional serology, I would still report the result, but you have to understand that you don't have a substrate control to see it. It gives you a little bit more information that maybe you have to be a little bit more careful about those results that are obtained from it, because it is not always possible to get a control.
How about a DNA test?
Vague as to which type of test.
Sustain.
PCR test.
I would feel that the answer should be the same, that you are getting information from the sample, but you have to also be aware of the fact that you don't have a control as to that particular sample, because sometimes it just is not possible to get a control for every sample you do.
Do you agree that if you take a control that doesn't show anything when you run the test on it, that doesn't necessarily mean there is not contamination?
It is not a 100% indicator that there is absolutely no possibility of contamination.
Do you ever examine the control swatches that the criminalists that work for you collect to determine whether they are clean or dirty?
Examine other people's controls?
Yes.
But when I was doing casework on a regular basis, I was seeing control samples regularly.
Do you as a supervisor?
No, I do not.
Do you have any kind of system to check on criminalists to make sure that they really are collecting controls as opposed to just putting a clean swatch in a bag?
That's our
Overruled.
No, we do not.
Now, you indicated that in your DNA laboratory, there had been a problem with contamination at some point, correct?
We had an indication of contamination, yes.
Now, the validation studies that you do involve taking known blood samples, testing them, seeing if the test comes out the way you expect it, correct?
Yes.
And you have run those validation studies in your PCR lab from the time you started doing casework through the doing of this case and after June, correct?
I have not. The people that do that type of testing continue to run those, yes.
And the contamination that you have testified to, when did that occur?
I don't have a specific date on it.
Approximate date?
Well, it would have had to have been sometime from when we started doing PCR in October of '93, and I know it was before June of '94.
How long did that contamination problem continue before it was detected?
I don't know.
Do you monitor that kind of information for the PCR lab that you're in charge of?
I was advised that it occurred, or was occurring at the time, and then I was advised that it had been cleared up.
Are there any reports or any documentation of that outbreak of contamination that describes how it was detected, what was done about it, how it happened?
Sustained. Sustained. Rephrase the question.
The contamination in your lab that you told us about, is there any documentation showing the nature of the outbreak, how long it lasted, what caused it, and what you did about it?
Still misstates the evidence.
Overruled.
It's argumentative as to how
Overruled.
quick.
Do you understand the question,
Yep.
Mr. Matheson?
There was none generated at the time. It was verbally accounted to me.
Are you familiar with Twig Dam?
Yes, I am.
What is that?
It's a organization that has been meeting for a number of years that has reviewed and suggested guidelines for doing DNA testing.
All right, do you want to spell that for the court reporter?
TWGDAM. That stands for Technical Working Group on DNA Analysis Methods, correct?
I believe so, yes.
And that's an organization of representatives from various crime labs that do DNA testing, have put together guidelines, correct?
Yes.
And these are suggestions for the operation of a DNA lab, correct?
Yes, they are.
Does your lab follow those guidelines?
I am advised by the people that do the work that these guidelines are followed as closely as possible, yes.
What does as closely as possible mean?
Well, we attempt,
Point no personal knowledge beyond the scope.
Sustained foundation. It's also beyond the scope.
Now, is your understanding that these guidelines are suggested minimum qualifications or minimum things that need to be done in a DNA laboratory?
Beyond the scope.
Sustained.
Do you know what the guidelines are with respect to documenting contamination in a lab? Do you have any idea?
Beyond the scope.
Overruled.
specifically, no, I don't.
Do you know whether your lab complies with that aspect of the guidelines with respect to documenting outbreaks of contamination?
Assumes facts, not evidence.
Overruled.
No, I do not.
What's your understanding of the cause of the contamination in your lab when it occurred?
I was verbally advised that we believe that it was traced back to a lot of the commercial kits that we had purchased, and that when we received one of the new lots, The contamination was no longer present.
Did you contact the man, or your people, your representatives contact the manufacturer to determine whether they agreed it was a bad lot?
My understanding they did.
I'm sorry?
My understanding that they did, yes.
Is it your understanding that the manufacturer agreed that it was their problem and not yours?
This calls for triple hearsay.
Overruled.
Not that they had said it was our problem, not yours, just that they were unable to duplicate what we had seen.
It was their position, was it not, that the lot was good, correct?
Sustained. We're way beyond the scope now, counsel.
When you were setting up the DNA laboratory, did you have occasion to review the Twig Dam guidelines?
I have not reviewed them all, no.
Have you reviewed any of them?
I have seen the document, but I've relied on the people that are actually setting it up to review them.
Are you familiar with the procedures that Twig Dam sets forth as a minimum for decontaminating a lab that has a contamination problem?
Beyond the scope.
Sustained.
Other than this contamination that you've talked about, now you can't tell us how long a period of time that took place?
No, I cannot.
Did it go on for a month? Do you have any idea at all?
I know it was not that extended period of time, but no, I do not know specifically how long it was.
You know, if it was more than a week.
I don't specifically know, no.
Do you have any procedures set up whereby you are advised when there is contamination found in your lab?
Overruled.
No, we do not.
Have you ever become aware, other than what you've testified to, any problems with contamination in your PCR lab since it started?
The definition of the word problems, we have had instances of contamination. It's the nature of the business in that occasionally you see types that you don't expect. If your controls are working and it's detected, I don't see where that is a problem. It's a existence. It occurs.
How often does it occur in your lab?
I don't know.
Do you keep those kind of records?
So beyond the scope.
Sustained. Let's move on to something else. I think we've exhausted this.
Mr. Batherson, you were asked some questions about item number 6. Do you recall those questions? Do you know what item 6 is?
I believe it was a swatch.
The bindle with the hair in it.
Yes, I remember.
All right. Now, when did you first become aware that there was a hair in the bindle?
Off the top of my head, I don't remember. I can try and look through my notes and see if I can come up with a date on that.
Well, it was when the items came back from Albany, correct? When item 6 came back from Albany?
I believe so, yes.
Did you check with your representative that was present to determine whether that hair was present at the time that bindle got to Albany?
I believe we asked him, yes.
Have you taken any steps to determine who the hair belongs to?
No, we have not.
Now, I think you indicated that that particular swatch was sent to DOJ after you got it. Was that for the purpose of determining whose hair it was?
I believe the hair was removed after we located it, and it was not part of what was sent.
Has any effort been made to identify where it came from?
I think the only thing that we have done is just a very quick attempt to determine whether or not we could determine race on the hair, but I'm not sure.
Are you aware that one of the lenses in the prescription glasses found between the two bodies is missing?
Yes, I am.
No personal knowledge beyond scope.
Overruled.
When did you become aware of that?
I don't remember the specific date.
What effort have you made or are you aware of being made to try and find that?
Beyond scope.
Sustained.
Has the job of finding that lens been assigned to you?
The job of finding it? No.
Yes. Is there somebody investigating it?
Beyond scope.
Sustained.
During the course of Dennis Funk's testimony, did you have any conversations with him about habits that he had formed in his testimony?
Sustained.
Did you have any discussion with Dennis Funk about the habit he had of saying that he did something when somebody else did?
No, I did not.
Did you ever review any prior testimony that Dennis Funk had given in other cases with him to determine whether he has done that before?
Not relevant beyond scope.
Sustained.
In your opinion, is it important that criminalists get to the crime scene as soon as possible?
Yes.
Now, you were aware at what time on the morning of the 13th that there was a crime scene?
Beyond scope.
Overruled.
I have to refer to my notes.
Sure.
Okay, I was made aware, excuse me, made aware of the fact that Mr. Fung was out on a crime scene at about 7:45, 7:50 on the morning of the 13th.
Did you become aware at that time that that crime scene had been discovered 7 hours before?
No, I don't believe so.
At what point did you become aware of that?
As soon as facts found evidence.
Overruled.
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 Oh, I don't remember.
What's the procedure, in effect, within the Los Angeles Police Department for calling criminalists to a crime scene in terms of when they should be called?
Well, whether or not a criminalist is called is left to the choice of the detective at the scene. And it's up to them as to whether or not when they arrive they call us right away. Sometimes they assess it. At some point they may decide that they don't need a criminalist and then change their mind and call us later on. It's up to the detective.
Is your understanding that that's the reason why they didn't call you for 7 hours, that they didn't know whether they would use you?
Calls for hearsay speculation.
Sustained.
Do you know why you weren't called for 7 hours?
Calls for hearsay speculation.
Sustained.
Did you ever ask, why didn't you call us when you found the crime scene?
Not relevant.
Overruled.
No, I did not.
Did that concern you at all, that you hadn't been called for 7 hours to come to this crime scene?
Not relevant.
Overruled.
I would have liked that we were called earlier, yes.
And did you take any action as a result of that concern?
No, I did not.
Now, did you find out early in the morning, 7 o'clock approximately when you said you found out, that Dennis Fung and Andrea Mazzola had been sent to Rockingham as opposed to Bundy?
At that time, I believe he just advised me that they were investigating a scene involving, or a crime involving a double homicide. I didn't get a lot of specifics at that point as to the number of scenes and all that was involved.
Did you make any effort to find out the nature of the scene or scenes?
Not relevant beyond scope.
Overruled.
He advised me what I felt I needed at the time. That's that they had arrived out at this crime scene and that it involved two victims. I inquired if they needed assistance and was advised not at this time.
Did he ever say anything to you to the effect, gee, they sent us not where the bodies are, but to some other scene?
Sustained.
Did he ever suggest to you that we need another team to get to where the bodies are?
Sustained.
Did you ever consider sending a second team to cover the Bundy crime scene?
I asked him if he felt he needed assistance, and I was advised that he did not, so I did not suggest sending another team out.
Where was he when you asked him that?
I don't remember.
Do you know what time he got to the Bundy crime scene?
No, I don't.
When did you become aware that the coroner moved the bodies before they were able to process the Bundy scene?
Oh.
I don't believe it was that day. It would have been probably a day or two later.
Now, I think you testified on direct that it's a mistake to let the coroner move the bodies before you process the scene. Am I?
Sustained. Misstates the testimony.
What's your feeling on the coroner moving the bodies before your people were allowed to process the scene?
From a criminalist standpoint, I'd have just assumed they left them there and allowed us to complete our work.
Would you consider it very important that you be allowed to do your work before the bodies are dragged over the evidence,
Sustained.
before the bodies are moved?
Yes, I would like it if they'd have left them in place, and that it is important that we be allowed to remove anything that is surrounding the bodies.
Do your criminalists have the authority to tell the coroner, wait until we're done?
No, they do not.
Do you have the authority to tell the coroner, wait until we're done?
Not to my knowledge, no. I can request it, but I don't believe I can tell them if they, and stop them if they felt so.
Do you have the authority to process or collect any evidence that is on the body?
My understanding is no, not directly. I have done it in the past, requesting it from the coroner's investigators that were there, but we have the scene. Their jurisdiction is the body.
Now, do you know, when I use the term a close-in crime scene, do you know what I mean by that?
I'm sorry, a what?
Close-in crime scene?
Not in the way you're using it now.
Let me define it for you. A crime scene where the bodies are very closely situated to the evidence. You have that in mind?
Okay.
In your opinion, is it an appropriate investigative technique when you have a close-in crime scene like that to move the bodies before the evidence is processed? Does that make any sense to you at all?
It's the same question that we heard about 5 minutes ago.
Who decides at a crime scene how it's going to be processed and in what order?
Depends on what you mean as far as processing.
Allowing the coroners to take the bodies.
Well, it's normally the detectives that call the coroner's office. I know in normal circumstances on crime scenes where I go to, more times than not, matter of fact, most of the times, the coroner's office is not even called until we have a chance to go through. The detectives wait for us to give the go-ahead that, okay, we are done in this area, and it's okay to call the coroner's office.
And that's the right way to do it, isn't it?
From the standpoint of the scene and the evidence, yes.
And when you teach the detectives in the homicide division the courses that you've told us about, you tell them that's the right way to do it, don't you?
Oh, I don't know if we specifically go into that, but I would if that was a subject raised, that we'd like to have as much time as possible to clear the evidence from around the bodies.
Now, did you have the authority to send a second team to Bundy?
Yes.
Did you know by 7 o'clock in the morning that this was going to be a very significant case with respect to the amount of resources it was going to take?
Well, at 7:45 is the first time I heard about it.
7:45.
I did not know the extent of the scene as far as that goes. A double homicide is not an extremely rare occurrence in this city.
Did you become aware rather quickly, though, that this was a case that was going to require substantial resources?
Thanks to rather quickly.
Sustained.
At some point that day, on the 13th, did you become aware that this was a big case?
I was made aware of the nature of the victims and that it had the potential of being a high-profile case, yes.
Did you take any steps to see that additional resources were applied to this case other than asking Dennis Fung, can you handle this yourself, or whatever words you used?
Argumentative.
And the only thing I did at that point, other than the fact that we did have a assistant director out at the scene and a captain out at the scene, I did inquire again midday of Mr. Fung if he needed assistance, and he advised me that none was needed at that time.
Do you know whether this was Steve Johnson you're talking about?
Yes.
Do you know whether he took any steps to see that extra resources were devoted to this case on the 13th?
No foundation of personal knowledge.
Well, the question was he aware of anything?
Do you know?
I don't believe he did assign any. He responded to the scene, spent some time there, and then returned to the laboratory.
Do you know whether he actually participated in collecting samples, or did he just kind of stand around and watch?
I believe he did not collect anything.
And I'm wondering if this might be an appropriate time.
Perfect. All right, ladies and gentlemen, we're going to recess as far as the jury is concerned for the afternoon. Please remember all of my admonitions to you. Do not discuss the case amongst yourselves, form any opinions about the case, conduct any deliberations till the matter has been submitted to you. Do not allow anybody to communicate with you. And as far as the jury is concerned, we'll stand in recess until tomorrow, Thursday morning at 9 a.m. All right, we'll take a 10-minute recess to clear the courtroom, and we'll proceed to the motions. For Mr. Kardashian in that matter. Good afternoon, counsel. Can I
Good
have your
afternoon, Your Honor.
appearance for the record, please?
Janet Levine and Alvin Michelson on behalf of Robert Kardashian.
Good afternoon, counsel. All right, I've read and considered the points and authorities filed by both sides in this matter, and counsel, I'll hear any additional oral argument that you have.
Thank you, Your Honor. With respect to the points made in the papers we filed as well as in the response papers we filed, there are a few points I wish to elaborate on. First, I want it clear to the court that this issue that's being raised here is one that Mr. Kardashian must raise as a lawyer. He is ethically obligated to refuse to testify, to avoid testifying in a case in which he represents a client. That ethical obligation rises from our adversary system of justice. That is, that a lawyer cannot be in a case as a lawyer and as a witness at the same time. The canons of ethics that control Mr. Kardashian and control every lawyer in this court state emphatically that a lawyer should avoid that position. And the reason that is because a lawyer cannot be part of a team that's advocating for a client and also have their own credibility, their integrity at issue in a case. It just doesn't work. A jury cannot decide a case when it's deciding the credibility of the advocate. And so this whole rule has developed in law that must be avoided. Usually what happens is a lawyer, if they see they're going to be a witness in a case, that they have testimony that they wish to offer on behalf of a client, withdraws. However, in a case where the opposing side wishes to call a lawyer, the burden falls on the opposing side to make a motion to disqualify the lawyer and to make that motion at the earliest stage.
In a timely manner.
In a timely manner. In the White case, which was cited to this court, it was a civil case, but the motion in that case was made prior to the summary judgment motion being made, long before a jury was even sworn or even contemplated, while the case was still in motions. And the court in that case said a motion made at that time was untimely. Looking at the circumstances in this case, the government has not even made a motion yet. But in this case, the jury has long been sworn. They've seen Mr. Kardashian as part of the team of lawyers representing O.J. Simpson for a very long time. They've seen him conferring with O.J. Simpson. They've seen him at sidebar with the court. They've seen him in that role. And it's not a matter that the prosecution can say has come up as a surprise, because they have this tape of Mr. Kardashian with the suitcase, which they showed to me early on. They've had that tape for a long time.
Counsel, when you say early on, what do you mean by early on? How do you define that?
I believe that tape was broadcast in June of 1994. I don't know that they had it in their possession, but I do know, since I represented Mr. Kardashian amidst the Cowlings grand jury matter, which is not this court's matter, that was before Judge Zulager. I do know that Mr. Darden was aware, and that was in July and August, I believe, and September of this year, of Mr. Kardashian's actions at that time. And that was long before the jury in this case was sworn. And Mr. Darden at that time was acting as the prosecutor in the Cowlings matter, not the prosecutor in this matter. This issue of the suitcase wasn't ripe at that time. That didn't come up, but Mr. Darden was in a position to be aware of what happened and was aware of what happened. The reason that they need to make the motion early is so that we can protect a couple of things. We can protect the integrity of the adversary system of justice, and also that we can protect the constitutional rights that lie with a defendant in a criminal case, in this case with Mr. Simpson. He has a Sixth Amendment right to have counsel, to have a continuity of counsel. He also has a right to confide in his counsel, attorney-client privileged issues, and to have his counsel work on his behalf. The proposed inquiry here is so broad and so far-reaching, and it's set forth in the papers that were filed by the prosecutor as well as in the letter sent by the prosecutor. They intend to ask Mr. Kardashian why questions. Why did you do this? Why did you do that? What tests did you conduct? Issues that go to the heart of the lawyer-client relationship, and issues that are not permissible for inquiry. My partner, Mr. Michelson, has passed me a note that says the tape of the suitcase has been shown on TV since the beginning of this case. And I don't know what the prosecutors have seen in this case. I'm not part of Mr. Simpson's team. Mr. Michelson and I are here representing Mr. Kardashian. But it's clear that they were aware of facts as early as when the grand jury was taking place. The cases cited by the prosecution do not support their calling Mr. Kardashian, putting him before the witness stand, having him sworn and testify to the jury. In fact, they support the opposite. The Meredith case, which is the seminal case in California, stands for the proposition that a lawyer cannot suppress evidence. But footnote 8 of that case, which was quoted in our moving papers, is quite clear. And it says, if a lawyer has information that the prosecution needs to get, the way it comes in is not through the lawyer testifying, not through any implication that the information comes from a client, but through stipulation, through finding a narrow group of facts that can be stipulated to. And the reason that is so the integrity of the lawyer isn't at issue. We don't want a jury to decide a case in our system of justice based on whether or not they like Mr. Kardashian.
Do you have a proposed stipulation?
I would be more than willing to sit down with the prosecution and figure out a stipulation that would work. I think that would need to be also with one of Mr. Simpson's attorneys. But that is what the case law provides. It provides for finding an alternative to putting the lawyer on the stand. And that's what we suggested as an alternative in our moving papers. We talked about footnote 8 in our moving papers, and it wasn't addressed at all by the prosecution in their opposition. And that is what protects the adversary system of justice. If there are facts that the prosecution wants out, and I'm not sure that's what they're seeking here, then let's stipulate to the facts. And let's put them before the jury and agreed on stipulation and not put the integrity of this witness at issue. That's his ethical obligation to propose that.
All right. Thank you, counsel. Ms. Lewis, are you handling this?
Yes, I am. Thank
All
you.
right. Good afternoon.
Your Honor, first I want to make clear that we're not seeking to disqualify Mr. Kardashian from representing the defendant as one of his several defense attorneys in this case. I think his participation in the case as a defense attorney, however, is different and distinguishable from the participation of all of the trial attorneys. I've counted 8 trial attorneys on the defense team who have acted as advocates in front of the jury in presenting evidence to the jury, at least one of whom will be arguing to the jury during closing argument. So we don't have a normal situation here where the attorney, the one trial attorney on a case, would be testifying and then put in a position of arguing his own credibility in front of the jury. It's a distinguishable situation. Meredith is clear, Your Honor, that the prosecution is entitled to the information that we're seeking, and we're entitled to it because Mr. Kardashian chose on the 13th of June last year to remove a full Louis Vuitton suitcase from the defendant's premises. Now, this footnote 8, which counsel refers to, does not really apply in this situation, in the Meredith case. The concern expressed by the California Supreme Court in that footnote was that it not appear to the jury or to the fact finder that, Your Honor, there is a great deal of discussion going on over here. If you could ask the...
Keep it down to a dull roar. All right. Thank you. Proceed.
Thank you. The concern in the Meredith case was, the situation in Meredith was that the defendant in that case told his lawyer, or told the investigator that he had evidence in some unknown location, and so the investigator went and got it from the location and then testified in front of the jury at trial. Implicit in that testimony, even though he was of course not asked that, was that the information as to where it came from, because it was very incriminating to the defendant, implicit in that is that the information as to where it came from must have come from the defendant. So the concern expressed in that footnote is that there not be a necessary inference that the information as to the whereabouts of the evidence, because it's incriminating, came from the defendant, so as to protect his attorney-client privilege communication to the investigator. We don't have that situation here. All of the evidence is already in the record as far as the relevance and the foundation for the bags that are at issue here, and particularly the Louis Vuitton bag. The limousine driver testified that that was the type of bag that was taken to the airport. The skycap testified that Mr. Simpson checked that into the airport. There's been evidence now that it indeed came back from Chicago because of the airline, the luggage tickets, which still remain on it. So there's all of the foundation, and we do now have a videotape of showing Mr. Kardashian leaving the defendant's premises with this same full Louis Vuitton garment bag.
When you say, Ms. Lewis, that you now have, how do you define now? When did this information become apparent to the people, and when did the materiality or potential materiality of Mr. Kardashian's testimony become apparent to the people?
As far as when we became aware that he took the tape, it's really difficult to say. We have seen, I don't know, and I don't think any of us can say for sure when we first saw the videotape. But when it became material was dependent on 2 things. First, on the fact that it became empty at some point in time, and second, and most importantly, on when the defense chose to put that bag before the jury. We had no intention of calling Mr. Kardashian as a witness or of introducing that bag prior, and we still had no intention of introducing that bag, but certainly no intention of questioning with regard to it until the defense in chambers brought forth the issue of these bags and elected, at that time, made a tactical decision to put that bag as well as the others in front of the jury. And when they did that, if that was something that they had been planning to do all along, they had an obligation. We're back to the discovery statutes again. Under 1054.3, it was real evidence they intended to introduce at trial. And they did not give us any indication of that intention. They supplied us with no notice of that, either orally in writing before that morning in chambers, either by a photograph or by an offer of to make it available to us for inspection, or in any other manner. So if indeed they just decided that morning or the night before to introduce those bags in front of the jury, that's when it became material, and I'm assuming that only because I have no basis to represent that they violated the discovery laws. So presumably that was the first time they intended to introduce that in evidence. So that's when it suddenly became important for the jury to know the true facts. And when they introduced it, it was empty. When we last saw it, it was full. Presumably it had, but we don't know this, but presumably it had clothing in it, which Mr. Simpson took to Chicago with him. Had the prosecution had that clothing and an opportunity to examine it, perhaps for blood evidence, for other trace evidence, there could have been critical information to have been gleaned from that. We elected not to pursue that particular baggage at some point in the case, and we would not have pursued it and would still not have pursued it, I don't believe, though you never know how a trial develops. But what made us pursue it in particular was the defense making an issue of it and bringing it before the witnesses who testified.
All right, so how do I get around the other legal problems, though, that are created by, I agree with you that Mr. Kardashian's participation has been minimal to date. However, he has been here in court. He was introduced to the jury during the course of the first 200 sidebars that we had. He was seen by the jurors consulting with the defendant at those times. So, I mean, he is present before the jury.
Well, this is an opportunity for him to explain, Your Honor, what his participation was, because as the court recalls, the testimony of Judge Wong revealed that when he went to Mr. Kardashian's residence is where he picked up the golf clubs, and when he was at the Mr. Simpson's home on Rockingham is where he recovered the Louis Vuitton bag from. And, you know, along those lines, Your Honor, I just wanted to mention when you and I and Mr. Carl Douglas of the defense team were out there the Friday before the jury view, to my surprise, I noticed that there were a few such Louis Vuitton bags up there on the shelf. And we don't know whether this was one of them or not. And it certainly was full the last time we saw it. So I don't think there's a problem under the facts of this case. And I think the problem, the concern expressed by Meredith, that it become, that it not be inferred that the information about where this evidence had been come from the mouth of the defendant is satisfied here because of the testimony I mentioned a few moments ago with the limousine driver and the sky cap, and the having testified that that appeared to be what he took to Chicago, and with the tags that indeed show it was checked into American Airlines on about the appropriate date. So that we have the foundation here. We don't need to ask Mr. Kardashian any question which would infringe upon his privileged communication with the defendant, and we're not seeking to do that. And that was the one concern expressed in Meredith. And in Meredith, indeed, the defense investigator testified before the jury, was asked on cross whether he was an investigator for the defense, and that he was allowed to testify to that.
Is there a possibility we could accept counsel's suggestion that perhaps there's a stipulation that would avoid Mr. Kardashian having to testify?
Well, there's certainly a possibility, but I believe we have attempted, I'll check with Mr. Darden on this, I believe we have, in fact, let me check before I make the representation, may I? Mr. Darden makes the excellent recommendation, which should satisfy our concerns and the court's concerns, that we have a 402 hearing outside of the presence of the jury and find out what the information is, and while Mr. Kardashian is testifying under oath as a witness. And that way we would have the relevant information so that we would know how to formulate a stipulation. And I think that's something that would also help us determine indeed whether a stipulation can be used and one is appropriate in this case.
All right. Thank you, Ms. Lewis. All right. Ms. Lewis, any brief response?
I might have a moment, Your Honor.
Certainly.
While they're still debating, just a couple of other quick points. I'm told, I wasn't present in chambers during the discussion, but I'm informed by both Ms. Clark and Mr. Darden that indeed the defense was informed that if they put these bags in issue, especially the Louis Vuitton garment bag, which had been full and was now empty, we would indeed be calling.
No, I recollect that. Yeah, it's part of the thought process at this point.
And Mr. Darden makes the additional point that back in August of 1994, he indicated that Mr. Kardashian had placed himself in the situation of...
It's in your papers.
Okay. One other point, which is not in my papers, and I'm sorry, I didn't talk about the White case, which counsel cites, because it's so clearly distinguishable. It was a civil case in which a summary judgment motion was brought, and just briefly, unlike what counsel represented, it was 6 months after the other side learned that for the summary judgment motion, which was denied, that the counsel would be acting as an advocate that they chose to disqualify, so it was clearly untimely in that case, and it was a civil case anyway, so it's clearly not pertinent here.
All right. Ms. Levine, what do you think about Ms. Lewis's suggestion that perhaps we have a hearing outside of the presence of the jury to determine the issues as to what happened to the contents of the garment bag
I think
and then
that-
see if that would form a factual basis for a stipulation.
I think it's excessive. I think it's not necessary. Mr. Kardashian is a lawyer. He's sworn to uphold the law. If he sits down, just like if anyone sits down under any circumstance discussing discovery or anything and makes a representation, we can try to reach a stipulation. If there's a problem then we can bring it to the court. It looks like, and I am obviously not the expert that everybody else in this courtroom is, that this issue is not going to come up in the next week, that the prosecution is involved in some more scientific evidence, so there is
That's a fair statement.
so that there is time for us to sit down and try to hammer out the parameters of a stipulation, and then if it's necessary, we'll bring up the issue to the court. But that's what I would prefer to do. I think it preserves Mr. Kardashian's ethical role in the most pristine manner, and if it comes up, then we can come back.
All right, what do you suggest is a reasonable timetable? My inclination is to order you to meet and confer with your client and representatives of the prosecution no later than early next week.
That's fine. I can't do it this week, Your Honor, because I'm already committed to
That's why I
things.
said early next week.
But I'm free from noon Monday and all day Tuesday, so either of those days with a representative of the prosecution team. I think there will need to be someone from the defense team, in addition to Mr. Kardashian, present as well, to make sure that while we're protecting Mr. Kardashian's obligations, Mr. Simpson's rights are protected.
I would nominate Mr. Douglas, since he's familiar with the breadth of this case.
I'll second that nomination.
And because he's absent.
Sanctions, Mr. Douglas, I was talking about sanctions and you were nominated. All right. Ms. Lewis, when do you think you and/or Mr. Darden would be available to meet with counsel? Early next week sometime?
Yeah, since Mr. Darden is in court and needs to be in court as much as possible throughout the trial as lead trial lawyer, Tuesday evening?
All right. How about Tuesday evening then at the break of the court session?
5
should-
p.m.?
How about 4:30 on Tuesday? Meet here in the courtroom. I'll give you the use of one of the empty jury rooms. You can meet and confer, see if you can work out something reasonable, and I'll be available to consult with counsel.
That's fine, Your Honor.
I do want to point out, Your Honor, we're not optimistic, considering Mr. Kardashian has been Mr. Simpson's friend for 26 years, and
Well, Ms. Lewis,
his bias seems
let's
obvious.
try to do it the easy way first.
Okay.
He is an officer of the court. He can provide a declaration under penalty of perjury as a factual basis. We'll try it the easy way first. If not, then we'll have a hearing outside the presence of the jury.
Can I just comment, Your Honor, if the court
Thank you.
pleases? I think we have to know...
Your Honor, I believe we have a one-attorney rule on
Oh, we
every
do.
issue.
I haven't been watching all the TV, Your
We have a
Honor, so-
one-attorney rule.
Your Honor, I think before that time, we do need to have a representation of exactly what the prosecution wants.
I think that's included in their moving papers. They've indicated clearly their interest is the garment bag, how it came into your client's possession, where it went, what happened to the contents, and how did it return to Rockingham. I mean, it's some pretty common sense questions.
And if there are any other tapes that they have of this, I've seen another tape that was provided to me that indicates that the bag was off the property and the police weren't letting it on. I don't know if there are other tapes like that that are available.
Well, I assume this will be during the part of your meet and confer.
Okay, that's perfect, Your Honor.
All right.
Here at 4:30 on Tuesday.
But I would also suggest that you and Ms. Lewis confer regarding appropriate ground rules as far as disclosure, what it is, specifically what it is, Ms. Lewis, you want, what you have available as far as the evidence, the videotape showing Mr. Kardashian with the item. All right?
Thank you.
All right.
Would it be possible to utilize the services of one of the court's reporters for this?
I know, I don't think the meeting needs to be reported.
I missed, it's not without reason. I think Mr. Darden certainly had contact with the individuals.
No, we won't do that. My court reporters are burdened enough as it is, believe me. All right, thank you, counsel.
Thank you, Your Honor.
Thank you.
All right, let's go on to the defendant's request for a hearing on prosecutorial misconduct.
my proposal.
Mr. Scheck?
It's my proposal that this proceeding be conducted in camera. And the reason that I propose that is that all we've ever asked for here is a factual basis, hearing on the factual basis from Mr. Harmon's statements about privileged communications with our experts, assertions that he made. That's all we ever asked. He made a response. To the extent that he may discuss privilege matters, or we may have to discuss privilege matters in response, or any of that has gone into, it seems to me that we should do that in camera. It shouldn't be broadcast, shouldn't be brought to anybody else's attention. Also, what concerns me is that we submitted to the court 2 declarations from the principals that Mr. Harmon, one with whom Mr. Harmon spoke, and the other is an individual who we believe is referenced in his response as the individual from the FBI, which creates factual conflicts. So it's my respectful suggestion to the court that if we do this in camera in chambers, A, it won't air all this possible privilege materials, which will be delicate, and B, maybe it'll keep the level of this down.
Isn't the issue not what was discussed, but the manner, the contact, and the confidential nature of the relationship between the defendant and certain of these experts?
Yes, I think I can do my side of it without bringing these things up, obviously, and even just argue the legal point. I'm a bit concerned about what's going to be said on the other side, and because the whole point of this was that assertions were made about secret testing, results of secret testing to the court. That's all we ever asked for an inquiry into. The factual basis for that, that's the problem.
Mr. Scheck, I'll hear your legal argument.
Well, my legal argument is a very simple one, Your Honor, and I would essentially rest on the papers and the declarations. What we have here is a situation where the defense, Mr. Harmon made representations in court, as is indicated in our papers, and the court is well aware from the record, about who tested what, on what occasions, what the results were, what the court should be knowledgeable of in terms of the results, in that he suggested we were misleading the court in other applications based on what results might have been or were, and he made specific assertions as to who did what when. His response doesn't make the matter any easier. It's our position that when samples are given to the defense for whatever purposes, and possibly testing that is to be privileged and in secret, that the prosecution should not endeavor to find out what the results of those tests are. Mr. Harmon's own response indicates that he personally conduct conversations with Dr. Reeders of National Medical Services and asked him questions about EDTA testing and about made statements to him to the effect that he knew that this lab hadn't performed those tests. And then in his papers he says that Dr. Reeders made responses to him in, quote, unsolicited comments, unquote. Dr. Reeders contests that in a sworn declaration. Similarly, Mr. Harmon in his response indicates that there was a conversation between a Special Agent Roger Martz in February of 1995 in Seattle with respect to EDTA testing with a representative of National Medical Services, who we gather from our research can only be Mr. Karl Slavaka, and that he indicated that in that conversation, S-E-L-A-V-K-A, and that Mr. Slavaka made statements about what was tested and that about the defense making requests to do and what they decided to do or not to do. And Agent Mart, Mr. Slavaka submitted a sworn affidavit where he denies that as well. Now, I mean, I think that there's some factual conflicts here that, frankly, I don't think we can resolve. My position with respect to the legal issue, and I really don't want to get into these factual conflicts. I don't think we can have a hearing now. There's no declaration, I understand, from Agent Martz, for example, and I think it's kind of tricky for Mr. Harmon to start making statements about what was said or not said in this kind of proceeding. But it seems to me that the legal principle is a simple one. When we're given samples to do testing and to evaluate with our experts, Mr. Harmon should not make efforts either through agents or personally to endeavor to find out exactly what we're doing. This sort of reminds me of a hearing one might have pursuant to United States versus Henry or that other series of cases I'm sure the Court's familiar with, when Sixth Amendment rights are being impaired by the prosecution sending in an agent to eavesdrop on conversations, or an informant, for example, into a jail cell to talk to a defendant, to conduct discussions about what the defense is or what's going on. And in those kinds of situations, you know, the issues are, was there interrogation? And were there questions about privileged issues? I find it troubling that in the Mr. Harmon's response, what he's telling us is that he got information from our experts in quote-unquote unsolicited comments. Now, it seems to me that what ought to happen is a factual hearing with respect to what was said and what the interrogation was. I think that Mr. Harmon's remarks, frankly, should be limited to the legal issue of whether or not he has a right to conduct this kind of inquiry. I guess what disturbs us is that we don't think that he has a right to make efforts to determine from experts that he thinks we've retained, and in fact have retained, to consult with us to know what those tests are and what we're doing. Our experts were unusually solicitous in responding to inquiries from the Los Angeles Police Department about the literature with respect to EDTA testing, because Dr. Reeders is probably the foremost authority in these kinds of matters and is often consulted by the FBI and others. So when Mr. Henkhaus from LAPD in January made an inquiry, as he indicated in a telephone conversation, asked for literature on the question, our experts sent him the literature, but wouldn't discuss his involvement with the defense or what he's telling us or what he's doing, as is what a person of his experience would do. And then when Mr. Harmon called him, he took the call, but refused to discuss anything about what he was saying to the defense or what they were doing. And Mr. Harmon, I think by his own response, was asking all these questions and making all these statements about what he knew had happened at other laboratories. I think that it's wrong for prosecutors to be doing this. That is wrong. They shouldn't be making these kinds of inquiries and conducting this kind of investigation into what they know are privileged defense activities.
Right.
That's the issue.
Assuming it's wrong, what sanction are you seeking?
Well, frankly, the problem is I don't know, without a hearing, the extent to which they have invaded the defense camp. A lot of specifics were stated by Mr. Harmon as to what he knew in these proceedings. Given the conflict in the testimony here, that we have declarations from defense experts saying that they didn't say the things that Mr. Harmon indicates they said, then I still don't know what the basis of his knowledge is. I know it can't be the little initialings on the envelopes. Otherwise, he didn't have a good faith basis to say what he said. So I think that further factual proceedings would be necessary to determine exactly to what degree we had an invasion of the defense camp. I'm by no means satisfied we know those facts. I suggested to Mr. Harmon, since I got these declarations late, that we put this over, because I think that other than the legal issue as to whether or not he has the right to ask these questions, we need to have a factual hearing on the extent to which there's an invasion. As to the precise remedy, again, I'm a little at a loss because we've yet to approach the time that the prosecution begins to put on witnesses with respect to EDTA testing, which I assure the court will be one of the most interesting pieces of testimony that we're going to see in this entire case.
All right, Mr. Harmon.
Sounds pretty bad, doesn't it, Your Honor? Thank you for not making us go on camera. If you recall the day that this motion was filed, the entire defense team held a press conference that afternoon. The whole rogues gallery was lined up behind Mr. Cochran, and they alleged we were following people around and intimidating Henry Lee. And so thank you for having this publicly so we can air the issue. Everything I know is in my response. I'd like to file something. I've given this to Mr. Scheck because it relates to Dr. Reeder's. One of the problems that there's a real conflict between science and the law. Scientists have no allegiance to people that pay their bills, at least honest, decent ones do. No matter how much money any defendant has, he doesn't own any scientist that he retains. And what I've given you is a letter faxed by Dr. Reeders to Leonard Hankhouse after Leonard's contact with Dr. Reeders in January, discussing what they discussed and inviting further discussions on the issue. And if you look at the response I filed, and by the way, I don't know what happened to Roger Martz's declaration. I've spoken to him a couple of times today. I can represent what it will say. They knew we needed it by 4 o'clock today, and I'm not sure where it is. But Agent Martz, and I'll submit it as soon as I have it, says, I talked to Carl Savaca in February. He told me they didn't do any testing, and I told Rock Harmon soon after that. And I think what's interesting about that is no one knew at that time that National Medical Services was involved. And so if Mr. Scheck wants to conduct some kind of hearing and make it be some kind of inquiry by Agent Martz was the most surprised guy in the bar in Seattle when in this social setting, Carl Savaca said, you know, we had that and we didn't do any testing, or words to that effect. There have been no efforts through any agents to get to the bottom of these things. You know, it's not surprising that we should have, again, this kind of attack because the defense knows what's about to happen. They had their fun in April, and we're going to set things straight in May. They know that evidence that I'll be presenting about item 13, the individual identification of that stain, about the stains on the glove. They know what's going on with 117, and they surely know what the results of the EDTA tests are. And that's what they don't want to hear. And that's why they want to try to intimidate us, and that's why they want to try to deter us. I have no problem with testifying. I'll be happy to testify. But I must insist that the people that filed those declarations testify. So let's take a look at them. Let's look at them at face value. There's a conflict. There's a real conflict here. And I think you can resolve this today, and I hope you do. If you don't, we'll be happy to set time aside, and I'll be happy to testify.
Well, I'd like to see at least the declaration that you're suggesting was due this afternoon.
I wish I knew. I was the most disappointed person when I went up at 4 o'clock and it wasn't there. But here, let's just evaluate these two declarations factually and then legally and see what they say. Now, they've alleged some kind of invasion of the defense camp as if it's some kind of Boy Scout escapade. Carl Savaca says he didn't tell Roger Martz what Roger told me he said, that they had the evidence and they didn't do the testing. And then Dr. Fred said he didn't tell me that they didn't do the testing. But he does admit that I told him that Roger told me that they didn't do the testing. Now, what the heck could I have told him? What would my basis have been for Roger telling me that if Carl hadn't told Roger that? These facts, they simply don't make sense. But even though they don't make sense, let's look at them at face value. They both deny that I knew anything. They deny that I know what I clearly know and what I put in my motion for this. But I think the real proof, or the real truth, or the real question here is it really just a coincidence? If you want to know whether Carl really told Roger that, I think if you look at 4750 and you say, gee, those look just like Carl's initials on those bindles there. You know, we're all handwriting experts. We can look at these initials, and if you look at them, Those are Carl's initials on there.
All right, you're referring to People's Exhibit, Mr. Goldberg?
This is People's 210.
All right, People's 210, which has the transmittal and packaging envelopes with regards to items 47, 50, and 78.
The real sequence of events are, they thought they got those samples in the middle of the night, and they were going to keep that fact from the world, and especially this jury. You know, we had those discussions in chambers the other morning that weren't reported. They don't even want the jury to know that they've looked at anything. They didn't like Hank's board about the Albany viewing.
Well, let's not get off into that.
Well, but I think that's at the heart of the matter. They want to strut around here and cross-examine people for weeks at a time and not have them know that they've looked at the evidence themselves. I don't blame them for that, but the law simply doesn't afford that, and you still have to rule on what's the appropriate scope of comment that we can make now that the jury's heard. It's out of the bag. They've had that evidence. So the fact of the matter is, when all the big fuss about the Albany trip came up and EDTA was the talk of the town, Roger Martz and Carl were having a beer or having fun up in Seattle. Remember we talked about people having fun in Seattle at the time? Carl mentioned that to Roger at a time when we knew nothing about National Medical Services. I was unaware that the LAPD lab, or no, I shouldn't say that. I was aware that they had contacted him in January, and I was really surprised because of that collegial type contact. So the items come back. We see that that's confirmed, that their initials and dates all over them. I call up Dr. Reeders to discuss the invitation that he extended to Leonard Hankhouse, the collegial invitation, and the rest is history. So if you need testimony, I'll be happy to submit the declaration. I wish I had it today. I'm sorry. I thought we would have it. But, you know, once again, it's much ado about nothing. But if you want to take the time from the jury, we've made a lot of progress. I'd hate to see us lose the momentum that we have. I'd be more than happy to testify if that's what you think the right thing is at this point, Your Honor.
All right, I would like to see the declaration from
Sure.
Mr. Marks. All right, brief response, Mr. Scheck.
Yes, I think Mr. Harmon's argument admits too much, and he did not address the most important point. Let us assume that everything that Mr. Solovska says is true, that there's a conversation between Agent Martz and Mr. Solovska in Seattle. And they discuss EDTA, and Mr. Solovska, as he indicates in his affidavit declaration, seems to know a lot about it, and even surprises Agent Martz. He's been thinking about it, but does not reveal anything about what he did in terms of testing or didn't do. Then, when the Bindles come back and Mr. Harmon takes a look at the initials and then has conversations, he begins to think, well, maybe I can figure out what they did and who tested what. So maybe I'll have a conversation with Dr. Reeders, and I'll probe him, and I'll say, well, you know, I know, based on the conversations that Agent Martz had with one of your people in Seattle, what you did and what you didn't do, and tries to elicit the information in that fashion. And then actually makes some inquiry with respect to the technology that's available at that laboratory and tries to make some educated guesses. Then comes into court and in a ploy tries to assert as fact what he is trying to piece together from the various bits of evidence. That is a possible view looking at all the facts in this case. My point, which he does not answer, and I ask the court to consider, is that prosecutors are not supposed to be doing that. You're not supposed to be calling up people and trying to conduct inquiries of them to determine what they've done and what they haven't done with respect to secret testing and throwing out hypotheses. So all the things that he points to as evidence to verify his view of the facts seem to me to do nothing more than call more attention to what could be, very well be, an act of misconduct. There's no justification for calling up Dr. Reeders, conducting an interrogation, trying to determine what he did or didn't do. Dr. Reeders said he did not make any unsolicited comments or say anything about what that lab did or didn't do.
All right. Mr. Harmon, you'll make sure I have that tomorrow. All right. All right, council, given the hour, I'm going to put over the discussion on the parity of sanctions motion until tomorrow morning, tomorrow at 4:30. All right, 4:30. All right, we'll stand in recess. Occurred in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Cochran, Mr. Blazier, people represented by Mr. Goldberg and Mr. Darden. Mr. Blazier.
Good morning, Your Honor. I had one other exhibit that I got last night that is a couple of excerpts from the California Association of Criminalist Code of Ethics that I may use this morning, and I provided the court with actually my only copy, so I told Mr. Goldberg about it, but he has not seen the copy. Also, we did not deal with knife number 118 yesterday. I think we all forgot about it. We need to deal with that this morning.
I'm sorry.
118, the knife that was ordered produced.
Okay. Do we have those reports?
I thought Ms. Clark either had them or gave them to the court.
No reports.
I have them all here, Your Honor. I thought she had given them to you as well.
Your Honor, is it permissible for us to handle this issue when Ms. Clark is here, since she was addressing the court on it previously?
Your Honor, I'm going to be getting into this relatively quickly. Ms. Clark said she was going to provide you with the reports. Mr. Goldberg knows what's in the reports. It's not terribly complicated.
All right. Do we have the item here?
Your Honor, yes, we do. Your Honor, as the court recalls, the people did ask permission to reopen, which the court said you would consider in the event that the court were going to allow us to get into this issue. So I just wanted to remind the court of that, because if that were the case, then perhaps
All right.
counsel would...
Is 118, item 118 here?
Are doing those things, it's okay.
What is not okay if it is touching an area which is dirty and is not cleaned prior to being used again.
If they are not aware that they're touching the ground, is it your belief that they are going to be aware if they happen to touch some evidence?
Sustained. Cause for speculation.
Begins to put on witnesses with respect to EDTA testing, which I assure the court will be one of the most interesting pieces of testimony I assure the court to see in this entire.
Sounds pretty bad, doesn't it, Your Honor? Thank you for not making us go on camera. If you recall the day that this motion was filed, gallery round, we can air the issue. Everything I know is in my response. I'd like to file something.
The people did ask permission to reopen, which the court said you would consider in the event that the court were going to allow us to get into this issue. So I just wanted to remind the court of that, because if that were the case, then perhaps
All right.
counsel would...
Is 118, item 118 here?
Yes.
Yes, it is.
All right. Unfortunately, Mr. Blazier, the reports that were just submitted to me appear to be 12, 15 pages. All right. I haven't had the opportunity to read them at this point, so until I have that opportunity and hear from the counsel, we won't get to that.
Well, then I would ask that we wait. That's part of my cross-examination, and I'm going to get to it probably within an hour or so.
Well, then why don't we proceed for an hour, and then when we get there, maybe we'll be at an appropriate time to break, and I'll be able to read the reports. All right? Any other comment?
No.
All right. Let's have the jurors.
Your Honor, may we have that copy back of, or at least have extra copies made so Mr. Goldberg can review it?
Oh, sure. I thought you had provided copies to Mr. Goldberg.
Yeah, that was my one.
All right. Maybe I can get one of the law clerks to make me a copy of these items. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. All right, Mr. Matheson, would you please resume the witness stand, please? Mr. Matheson is undergoing cross-examination by Mr. Blazier. Good morning, Mr. Matheson.
Good morning.
You're reminded, sir, you are still under oath, and Mr. Blazier, you may continue with your cross-examination.
Thank you, Your Honor. Mr. Matheson, good morning.
Good morning.
Ladies and gentlemen, good morning. Mr. Matheson, I'd like to ask you some questions about Mr. Simpson's reference blood sample. That's item number 17, correct?
Yes, it is.
And that had originally been logged in as item number 18, and the number was changed on it, correct?
Mistakes, the evidence is to log in.
Sustained. Rephrase the
It had
question.
originally been recorded by Mr. Fung and Ms. Mazzola as item number 18, and that number was changed, correct?
That's correct. At some point it was believed to be 18, and then it was corrected.
Would you agree that the suspect's reference sample in a criminal case is an extremely important piece of evidence?
Yes, it is.
And could you use the analogy that with a wheel, all items of evidence are compared to that, correct?
To that and other reference samples, yes.
And that reference sample, in effect, is the hub of the wheel from which everything else is looked at, correct?
Along with other references, yes.
And if the integrity of that reference sample is compromised in some fashion, then that would affect the validity of the analysis of other things that are compared to it. Would you agree with that?
Oh, yes, if there is some problem that compromises the validity of it, then there is a concern, yes.
And would you agree that with respect to blood samples, many tests can be run on extremely small amounts of blood samples?
That's correct.
And would you agree that by virtue of that, that very small amounts of blood could be used, hypothetically, to contaminate large numbers of items of evidence?
Vague, overbroad.
Overruled.
I'm not sure what you mean by very small and large quantities. You could well, if the samples come in direct contact with each other, sure, there could be transfer and contamination.
And we talked about yesterday that as small as 1 or 2 nanograms, 1 or 2 billionths of a gram of blood can be tested, and you can get results using DNA testing, correct?
Misstates the testimony.
Overruled.
That very small quantities, yes, can be detected and tested.
Now, would you also agree that blood, in a sense, is anonymous in that by just looking at it, you can't tell where it came from, can you?
No, you cannot.
And by the same token, a swatch that has what appears to be blood on it, just by looking at that, you can't tell anything about where that came from, can you?
That's correct.
Now, when blood is drawn from a suspect, it is done in a hospital setting, is it not generally, or a medical setting?
Irrelevant.
Overruled.
In a medical setting, yes.
The detectives don't do that in their office, do they?
No, not normally.
It's done by a trained person who knows how to draw blood, correct?
It's my understanding, yes.
Now, have you drawn blood before yourself? Do you know how to do that?
No, I don't.
Have you seen it done?
Yes.
Are you familiar with the techniques that are used to draw blood?
Only on those that have been used on me.
Are you familiar with the technique where a syringe is used to take blood out of a vein, and then the syringe is injected into a vacutainer?
I've heard about it. I've never seen it done.
And the vacutainer, or the tubes that we've been talking about, you were shown a couple of them yesterday, or the other day, you recall those?
Yes, I do.
And they are manufactured with a vacuum inside. That's why they're called vacuum tubes, correct?
That's correct.
So that when a needle is stuck into a vacutainer, it tends to suck in whatever might be in the syringe, correct?
Well, as far as... Well, there is a vacuum. It's going to try and draw in whatever is stuck into it if there's a needle with an opening in it.
And do you know how much blood would be drawn in, given the amount of vacuum in a vacutainer, how much blood would be drawn in just on its own coming in from a syringe? In other words, nobody's pushing on the end of the syringe. Do you have any idea?
No foundation for
Sustain, rephrase the question.
Do you have any idea how much blood would be drawn into a vacutainer, given the amount of vacuum that is in those containers, if you just stuck a syringe with blood in it in the top without pushing the plunger down?
It's an incomplete hypothetical and no foundation.
Foundation, sustain.
Have you ever done any experiments on trying to determine how much blood goes into a vacuum tube because of the vacuum in that tube?
No, I have not.
Here, I have an exhibit I'd like to mark.
Mrs. Robertson. $11.35. And Mr. Glazer, what is this?
This is a vacutainer that contains some cranberry juice.
All right.
Mr. Matheson, let me show you this exhibit, which is 1135.
11:35.
And I showed you that, I believe, yesterday, did I not?
Yes, you did.
And I gave you a measuring device so that you could verify how much cranberry juice was in that vial, did I not?
Yes.
And we verified that there are approximately 8 milliliters in that vial, correct?
But when I poured it off and measured it, I measured 7.5.
And we noticed that there was some still in the bottom of the tube, correct?
That's correct.
So there is 7.5 plus what was in the bottom of the tube in that vacutainer, correct?
Correct.
Now, you described that, I believe the other day, as a 10 milliliter tube, didn't you?
That was a assumption I had, yes.
It actually holds, if the cap is off, a lot more than 10 milliliters, doesn't it?
Yes.
It holds approximately 14.
I don't know. I would want to measure it.
Okay. And when you were estimating on the stand 2 days ago, I believe, how much blood would be half of the vial, you measured from the top of the cap to the bottom of the vial, did you not? I think you put your finger on the top and your thumb on the bottom, or maybe the other way around.
Actually, not to the top of the cap, but to the top of the glass part of the tube.
Now, 8 milliliters of blood in that tube would essentially look very much like that, would it not?
Well, the fact that I measured it yesterday, yes.
Now, is blood heavier or lighter than water?
Blood is slightly heavier.
Do you know about how much?
Not very much
Not
at all.
very much.
There is a slight difference, though.
Do you know how much that vial weighs?
No, I don't.
It weighs very little, doesn't it?
That's vague.
Can you estimate the weight of that vial?
Not just by feeling it, no.
Is it important that blood samples, such as a suspect's reference sample, be transported carefully?
Vague is to carefully.
Overruled.
Well, you want to transport anything carefully, particularly if you're dealing with a biological sample, so you don't spill it.
You don't want to break it either, do you?
No.
And is it appropriate for one criminalist to put a sample of blood in a trash bag and give it to another criminalist to transport without telling that criminalist what it is?
Argumentative calls for any collusion.
Overruled.
I don't think it's inappropriate, no.
You would recommend that that's okay to put that in a trash bag, give it to somebody, don't tell them that it's in there, to let them carry it around?
Argumentative, asked and answered.
Overruled.
Well, if I would be concerned if just a vial was dropped into a trash bag or something and then handed to it, but the fact that it is in other packaging and there's a little bit of padding there, I don't think it's wrong in doing that.
How about taking that trash bag and leaving it on a counter or on a table overnight without telling anybody that it's in there? Would you recommend doing that?
It's not a great procedure, no.
And you have janitors at SID, correct?
Yes, we do.
Now, I want to go through the records that are maintained at the lab with respect to all records that you have of withdrawals from Mr. Simpson's reference tube. Do you have that in mind?
Yes, I believe so.
Now, I want you to assume, for purposes of a hypothetical, that you started with 8 milliliters of blood, approximately. You have that in mind?
Okay.
Now, your records indicate, do they not, that on September 14th, criminalist Colin Yamauchi withdrew approximately 1 milliliter of Mr. Simpson's reference blood.
I remember that reference, yes.
And do you need to look at the record to make sure of that?
It would be good, yes.
Okay. Let me show you a serology item description note.
Okay.
And that's consistent with what you said, is it not?
Yes, it is approximately 1 milliliter.
Now, on June 20th, blood was withdrawn for purposes of doing toxicological analysis, correct?
I don't know the exact date. I'd like to see a record of that, too.
Sure.
please.
Let me show you a toxicology document.
Okay.
And that indicates that as of that date, there was 5.5 milliliters, correct?
Objection, no foundation for business records, hearsay.
Sustained.
You recognize that document as a regular form that's used in your toxicology unit?
It looks familiar, yes.
And those are filled out in the regular course of business of the people that work in the toxicology unit?
I believe so, yes.
And do you know who filled that out?
Well, looking at the initials, that is not one of my units, and I have not worked with this person, but the initials are consistent with Elisa Flaherty.
And are those are filled out during the normal course of conducting an analysis, correct?
It's my understanding, yes.
And they're filled out, I'm sorry, were you done?
Yes.
And those are filled out at the time that the testing is done, correct?
I said it's my understanding, yes.
And does that appear to be,
No foundation.
and that indicates that as of the 20th, there were 5.5 milliliters in that reference sample, correct?
That's what the form indicates.
Now, on some point around June 27th, Mr. Yamauchi withdrew some sample from the reference tube for purposes of doing electrophoretic analysis, correct?
Okay, I'd like to see the record. I believe he did a notation of having removed some portion of the blood on the 25th.
Okay,
June.
let me show you a record. And what is a thread, by the way?
A thread is a small portion of cloth.
Just like it sounds.
Yes.
And when you use the term a thread in the context of electrophoretic analysis, what does that mean?
Well, thread is used, you put the sample on it, whether it's extracted from another item or a whole blood sample, let it absorb onto this thread that's approximately a centimeter, a little over a quarter-inch long, and that's what's placed in that gel that was shown a few days ago.
Now, I want you to take a look at that document I gave you and see if that refreshes your memory about some of that reference sample being removed on the 27th.
Seems much not an evidence that we had a number of it.
Ooh. Yes, this does indicate that on June 27th, some threads were
And that's
prepared for electrophoresis.
I'm sorry. And that's your note
Yes, that's in my writing.
of your observation of that thread being removed.
Oh, threads, yes.
Now, approximately how much blood is necessary to make a thread?
Oh, I've never measured it, but the quantity of blood to actually make the threads is quite small. Matter of fact, it may even be less than the amount of blood that's left in the pipetter that we use to withdraw the blood.
Okay. Now, on the 25th, the records indicate that there was another withdrawal from the reference sample, correct?
I believe so, yes.
And let me, would having a record of that help refresh your memory?
Yes, it would.
still state specs not, I mean, assume specs not in evidence that he had a memory.
Sustained. Sustained. Sustained.
Do you have a recollection of blood being withdrawn approximately the 25th for certain types of analysis?
I was not present at that time, but I was made aware of it.
And you've reviewed the records about that, have you not?
Yes, I have.
And you remember what's in the records, don't you? Or do you?
Not everything, no.
Would it help refresh your memory to see the records?
Yes, it would.
Yes, Your Honor.
Okay.
Now, does that document appear to be a form document that's used in your laboratory?
Yes, it is.
And are those filled out at the time that the actions described in the document are taken?
At or about that time, yes.
And does that appear to be filled out in the appropriate manner?
Yes, it does.
And do you recognize the handwriting?
Yes.
Whose handwriting is it?
The majority of it on the page is Mr. Yamauchi's.
What does that document indicate with respect to the removal of blood from Mr. Simpson's reference sample at that time?
No foundation.
Overruled.
It indicates that on June 25th, there was approximately 3/4 of a milliliter removed
And that was for what purpose?
for, I believe, ABO typing and some initial electrophoresis work.
Now, is there any indication on that record about an additional amount being withdrawn for toxicology?
Well, it doesn't reference it being removed for toxicology.
What is that reference?
That refers to the quantity of blood that's present in a microcentrifuge tube that was with the blood vial.
Now, microcentrifuge tube, that's a little tiny tube that has a kind of almost a pointed bottom, correct?
It's a plastic tube, correct, that has kind of a conical shaped bottom with a snap cap on the top or a screw top cap.
And that holds about 1.5 milliliters?
Yes.
Now, that record indicates that as of the date that Mr. Yamauchi withdrew 3/4 of a milliliter for serological purposes, that there was a microcentrifuge tube there with the reference vial, correct?
That was packaged with it, yes, that's correct.
And you're familiar with that little microcentrifuge tube, are you not?
Yes, I am.
You've seen it and you've measured it, haven't you?
Yes.
And how much blood is in that microcentrifuge tube now?
At this moment?
Yes.
I don't know.
How much was in it when you measured it?
I would have to reference one of my notes.
Sure.
Trying to locate the date in which one of those determinations was made.
You need a straight edge.
No, thank you. Okay, I have a reference from September 21st that gives a total measurement for the blood vial and the microcentrifuge tube. I did not delineate how much was in each.
And that indicates what?
On September 21st, 1994, that there was approximately 3.8 milliliters total of blood.
Now, you recall in January of this year that you measured as precisely as you could the amount of Mr. Simpson's blood that was left.
I would want to confirm that.
Why don't you check your records?
I have a reference in my chronology that a request is made by Deputy Goldberg to determine the quantity of the blood present. I did not record on that chronology what that amount was.
What did you determine the total amount to be?
At that point, I don't have notes on it. I believe I just telephonically advised him. On January 4th, 1995.
I have two pictures I'd like to have marked.
$11.36, do you want to do A and B, or $11.36 and $11.37?
1136 A and B.
All right.
Let me show you a photograph, 1136A. Does that appear to be the blood tube, the reference sample of Mr. Simpson with the microcentrifuge tube?
Yes, it does.
And let me show you 1136B. Does that appear to be another picture of the same thing from a slightly different angle?
Yes, it does.
Could I display these on the Elmo?
Yes.
Looking at 1136A first.
All right, Mr. Blazier?
Now, Mr. Matheson, that's the photograph you identified as Mr. Simpson's reference sample, correct?
Yes.
And that little tube at the bottom is the microcentrifuge tube that we were talking about?
Appears to be, yes.
And that was a 1.5 milliliter tube. That's the capacity of that little one, isn't it?
Mr. Harris, we need to see the bottom of that.
There we go.
Yes, that's a standard quantity for those tubes.
And what does the business record indicate was remaining in that microcentrifuge tube as of approximately June 25th?
According to Mr. Yamauchi, he put approximately 3/4 mLs or milliliters.
And that indicates that that microcentrifuge tube, that was the blood withdrawn for the toxicological analysis, doesn't it?
As to what indicates?
The business record that you have in front of you.
It does not specifically say that's what it was for in this record, no.
Would you agree that there is a number, 1477, associated with that entry?
Yes, there is.
And what does that stand for? Do you know?
I believe it's a reference number in toxicology.
So, and that's a number that's assigned to a sample of blood when it's sent for toxicology, correct?
I don't know the inner workings of their unit, but it's a number that appears on the tube.
And is that the ID number of the technician that does the work generally?
I don't know that, no.
$11.37.
11:37.
Matheson, let me show you 1137. That appears to be another photograph of the vial.
Yes, it is.
And do you see initials on there, on that vial? WF.
I see initials. It's not WF.
What is it?
I believe it's LMF.
And LMF is who?
I believe that's Lisa Flaherty.
And she's the person that does toxicology, correct?
She works in that unit, yes.
And is there a number next to her initials?
Yes, there is.
What's that number?
I'm not sure. Yeah, I don't know. I don't know if that's her serial number. I don't believe it is.
No, I'm sorry. I meant what? Tell us what the numbers are.
Oh, I'm sorry. It's
Check that there's no foundation for the photograph when it was taken. Also discovery.
Sustained.
Your Honor, on the latter objection, could I be
Sustained.
heard?
Sustained.
Mr. Matheson, do you recall, I believe in January, when I visited the lab along with Mr. Taylor and Mr. Scheck?
I know you were there, yes.
Let me show you 1136B again. You remember us taking photographs and measurements of the reference tube?
Yes, I do.
I object on the same grounds, foundation and discovery.
Overruled.
Recognize your hand in that picture?
I'm not sure if that's my hand. I do remember manipulating the vial.
Okay. Is there any doubt in your mind that that's Mr. Simpson's reference blood vial?
No, there's not.
Okay. Now, I'd like you to look at the purple top on that vial.
I still object on discovery grounds.
All right, let me see counsel at the sidebar.
Okay, Lori, see you later. Is that right? Does that work? It works. She says, have to peel potatoes for a bit. It's great to chat with y'all. Alien has been abducted by the entity known as Bubbles. That's very cool. Lori, you sound like you have an amazing dinner getting prepared. So, and y'all have a good meal. Yeah. Bubbles has abducted me, indeed.
Let me again show you 1136A. And I want you to look at the top of that vial between the purple top cap and the glass. Can you see that?
Yes, I can.
And do you agree that there appears to be blood smeared on the purple top cap in that position?
There does appear to be small quantities of blood in the cap, yes.
Now, when you withdraw blood from a reference tube such as that, you don't pour it out, do you?
No.
You take a pipetter and put it in the blood, take the blood up into the pipetter, and then take it out, correct?
Correct.
And the proper procedure is to do that presumably without spilling the blood all over the vial, correct?
Of course, you try and be as careful as possible.
And that's the standard procedure that's used anytime a trained person like yourself removes blood from a vial like that, correct?
That's correct.
Your Honor, the ELMO doesn't portray this very well. May I have the jurors view these pictures?
Yes. And if you just hand them, as soon as you finish looking at them, hand them to the next juror so we can speed this up just slightly.
You have that hypothetical in mind?
Improper hypothetical.
Overrule.
Your Honor, I'd like to use another exhibit at this time.
Not at this point.
May we approach?
No. We've already had our discussion on this. Proceed.
Between the taking of that reference sample on June 13th and the time that you measured it in early January, are there any other records, business records of your agency or the Los Angeles Police Department of withdrawals from that reference sample?
There are no records that I can recall, in addition to the ones that we've talked about, other than what is implied by the testing that I did, and I did not specifically record that I'd withdrawn a certain amount.
So that you're aware of no other withdrawals from the business records from that blood other than the one you just alluded to?
As I'm sitting here right now, I would, to be absolutely positive, I would like to go through all of the pages and notes that were between that time frame.
But you reviewed all the notes in preparation for your testimony, haven't you?
I've reviewed many notes, yes. It's quite voluminous.
And you've known for quite some time that the issue of how much blood was taken out of that tube has been an important issue, haven't you?
Vague, argumentative.
Overruled.
Yes, I've been aware of the issue.
Your Honor, I would like to use the exhibit.
No. It's a foundational problem still, counsel, as I indicated to you. You can use it when there's one more piece of the foundation there. Proceed.
May I have a moment, Your Honor? Mr. Matheson, every time something is taken out of that reference tube, initials are put on the tube. Isn't that correct?
Whenever somebody uses that tube in some way as far as testing or removal of a sample, they're supposed to initial it. That's correct.
Let me show you, again, exhibits 1136A and B and 1137, and ask you to tell me each and every initial that's on that blood bar.
Okay, I see one, as mentioned earlier, that was LMF.
And that would be for toxicology, correct?
That's correct. There's what appears to be an initial above that that I don't recognize. I'm not even sure I can read it. Above that on the tube are my initials with the date 6/27/94. And then above that appear the initials of Colin Yamauchi of 6/25/94.
Mr. Matheson, let me stop you for a second. And would it help you to look at a record of all of those initials in your handwriting?
Sure.
Apologize, I think this might be easy. Is that a business record in your handwriting?
Yes, it is.
And that's a recordation by you of all of the entries or initials on that blood vial, correct?
No foundation
Overruled.
under business records exception.
Sustain on the business. Are you going to use the record or using this to refresh his recollection? What are you doing here?
Let me ask you, did you make that particular document in the regular course of your business?
Yes, I did.
And you did that at a time when you were actually looking at the blood vial and the paperwork to determine what was on the blood vial?
Yes,
And you wrote it down as you did it?
that's correct.
Thank you. Your Honor,
No
Could I-
foundation.
You want to mark this as 1138?
yes.
Objection, no foundation.
Overruled.
Now let me show you 1138, and could you tell us from that record what withdrawals are indicated, or what are all of the withdrawals that are indicated from that record?
Assumes facts not in evidence that indicates withdrawals.
Overruled.
You could list them in chronological order, please.
The there's no information here that says when withdrawals were made. There are initials and there are dates. It doesn't specify what work was necessarily done on each of those times.
All right, let me ask you a question. When someone takes blood out of that for purposes of doing work, they initial it at that time, correct?
That is one of the reasons, yes.
And they write down the date that they do that, don't they?
Normally, it's not required.
But if they wrote down a date, there'd be no reason why they would write a date different from the date they put their initials on there, correct?
Calls for speculation.
Overruled.
Is that correct?
They shouldn't, right.
Okay. What are the recordations on that blood vial in terms of people having access to it and taking things out of it?
So I should, because there are references here that are not for when things were taken out.
Okay, well, let's go through all of them, and then we'll pare them down.
The ones that I see on this record is the J1477 LMF.
And what's the date of that?
There's no date associated with that.
Okay.
GBM 62794.
And that's you.
That's correct. CY for Mr. Yamauchi 62594. And then a 61494 CY. Those are the markings that are on the tube itself, according to my record here.
Now, there are also markings on the envelope that the tube is contained in, correct?
That's correct.
And they also indicate when people initial opening that envelope, correct?
That's some of the information that's here, yes.
And tell us what those entries are.
There is one that is CY 61494, a GBM 93094, followed with the notation for split, then GBM 1495, followed by the notation to determine quantity.
Is that in your handwriting? I mean, I'm sorry, that's the entry that you made, is it not?
Yes, it is.
Okay.
There is also as far as notations that appear on the envelope, also I have referenced here a note by Fung that says received from Van Adder 61394.
Now, going back to the tube, now, can I put that on the envelope, please?
Sure.
Can you focus a little better? The vial is the, in terms of dated, is CY on 614. That's Colin Yamauchi, correct?
That's correct, along with the number 18.
And would you agree that that corresponds to the record that you've already identified as Colin Yamauchi's withdrawal on the 14th of approximately 1 milliliter for DNA testing?
Well, I believe that 1 milliliter was for swatching, yes.
For swatching, okay. And would you agree that the entry of CY Colin Yamauchi for 625 of 1994 corresponds to the record that you identified where he indicates 3/4 of a milliliter taken for himself and the presence of the microcentrifuge tube with 3/4 of a milliliter?
Calls for speculation, conclusion, opinion.
Overruled.
Well, that entry is no longer visible on the screen, but yes, it corresponds to that
Okay.
time.
And the entry in your initials on the 27th, would you agree that that corresponds to the withdrawal that you made, that you indicated you made no records of?
That I didn't record the quantity that was removed, that's
Okay.
correct.
And did you make any recordation at all about work that you did on the blood that you removed on that date?
There was analytical notes, yes.
Do you have those notes here?
Yes, I do.
Could I take a look at them?
It's associated with the report that was written, completed on 6/28/94. There's one blood analysis summary sheet, a blank or a not form page where I recorded some data along with the serology item description notes, and then some electrophoresis pages that actually cover a couple of different days.
Now, would you agree that that blood analysis worksheet was filled out by Colin Yamauchi, not yourself?
Actually, we both have entries on here.
Okay. So you both did the same work at the same time?
Well, he started some of the work 2 days before, on the 25th, and then I was involved and completed some of the work on the 27th and the 28th.
Then the 3/4 of a milliliter he indicated on those records that you're referring to is what was taken out for the work that you and he did during that period of time, correct?
This mistakes the evidence because
Sustain.
Is it correct that the 3/4 of a milliliter entry that you've already testified about around that time, that's the work that you and he did that you just testified to?
still misstates the evidence.
Sustain.
Is there an entry in the records indicating the withdrawal of blood from that vial for the work that you just testified to?
There's an entry of the work that he did, but there is no quantity mentioned for the work that I did.
So are you telling us that you took blood out of that vial to do work and made no entry anywhere of the withdrawal of that blood?
Asked and answered, argumentative.
The fact that blood was removed is implied by the fact that I did work on it and received results from it.
Do you agree that withdrawals of anything from evidence, when you take something away from a piece of evidence, should be fully documented?
Overbroad.
Not anything and fully documented, no. The fact that results were obtained on an item implies that we removed blood from that item. I described the item that's worked on, and results are obtained from it. There is no reason to make exact notations of the quantity that is used, particularly in a liquid sample from a living individual.
Is there a reason to make any notation?
There is notation in that work was done on it and results were obtained.
Now, I think you indicated that that particular withdrawal was approximately 1 milliliter, correct?
I believe I gave a range that it could have been from 1/2 to 1.
And how much actual blood do you need to use for the testing that you did? It's not very much, is it?
For the ABO test, it would take about, the actual test consumes about 6 drops. The electrophoresis altogether probably doesn't even take a drop, but there are things such as the blood clinging to the sides of the pipettes and that type of thing, and that'd be it.
Okay. Now, so the testing takes, I think, about 6 plus, just 6 drops total?
Probably 6 to 8, somewhere in there.
And there are how many drops in a milliliter, approximately?
Approximately 20.
Now, the blood that you didn't use for that particular withdrawal, you put back, didn't you?
Not necessarily.
Do you recall talking to Mr. Regal in about August, at the time that he visited the lab, about whether you put that blood back or not?
Yes, I do.
Recall telling him that you put the blood back?
I believe I said I thought I did, yes.
And so that if you put the blood back, then all of it would go back into the tube with the exception of the 6 or 8 drops that you used plus what might have clung to the tube.
That's correct.
And have you ever done any kind of test to determine how much would cling to the tube?
No, I have not.
Mr. Matheson, I want you to assume for purposes of a hypothetical that you started with 8 milliliters of blood. Do you have that in mind?
Okay.
I'd like to use the exhibit.
Nope, I still told you, you have one piece of the foundation that's not there yet.
Your Honor, to save some time, may we approach?
Proceed. We've had this discussion, counsel.
All right, Mr. Matheson, for purposes of this hypothetical, let's assume that 8 milliliters of blood was drawn from Mr. Simpson on the 13th, okay?
Okay.
And the toxicology records indicate that on 6/20, there was 5.5 milliliters left, correct?
No foundation for the hypothetical.
He's testified to the
Assumes
record.
facts, not in evidence.
Overruled.
Okay.
And the only withdrawal from Mr. Simpson's blood between the 13th and the 20th was Mr. Yamauchi's 1 milliliter, correct?
That's correct.
And would you agree that under that hypothetical with those figures, as of the 20th, there is approximately 1.5 milliliters of Mr. Simpson's blood unaccounted for?
Improper hypothetical, Your Honor, argumentative, no
Overruled.
foundation.
Approximately, that would be the difference between what toxicology approximated on their date versus what is being told to me in the assumption of starting with 8.
And approximately how many drops are at 1.5 milliliters?
Well, if we assume that there's approximately 20 in 1 milliliter, that would give us about 30 drops.
And 1 drop of blood, depending on the size of the swatch that you use, you can make at least 5 swatches, can you not?
Depending on the size of the swatch, sure.
You could actually make more than 5, correct?
You can make 4 and you can make less. Yes. Or more.
So
or
that if you
less.
use this, I'm sorry.
I was going to say, depending on the size, yes, you could either make more or you can make less.
So that if you used a size swatch that allowed you to make 5 swatches per drop, with 1.5 milliliters of blood, you could make 150 swatches, couldn't you?
Given that hypothetical, yes.
Now, I think you testified on direct that blood that is collected in a vacutainer has a preservative in it called EDTA, correct?
In this particular tube, yes.
And that is a chemical that's put in there to keep the blood from coagulating, correct?
It's my understanding, yes.
And there are procedures that are available to determine whether that particular chemical is present, correct?
No foundation to this witness.
Rephrase the question.
Are you aware of procedures available called gas chromatographic mass spectrometry to determine the presence of that chemical?
I know that GCMS, which is the short version of the instrument you used, does exist, and it's used for identifying different types of chemicals and things. I don't know of any specific procedure. I've never been involved in testing for EDTA, but I would assume it could be done.
Now, hypothetically,
No foundation for any further questions on this line.
Haven't heard the question.
I'm sorry?
Haven't heard the question.
Hypothetically, Mr. Matheson, if blood from this case, from an evidence item such as from the back gate, showed the presence of a chemical, EDTA, would you agree that that is consistent with it possibly coming from a reference vial?
That is an improper hypothetical. It's inconsistent with the known facts.
Overruled.
As you stated it, if it was present in it, if it was able to be identified in it, it is possible that it could have come from some type of reference sample that previously contained EDTA. I don't know what the sensitivity limits are of the instrument or exactly how much EDTA is placed into a tube, but given the hypotheticals you stated, it's possible.
And hypothetically, if there was the chemical EDTA found in the blood on the socks, would your answer be the same, that that would indicate that it may have come from a reference file?
Your Honor, improper hypothetical, no facts, no foundation for it. Argumentative.
We would also have to assume or make the assumption that there's no other source of EDTA that could have gotten on those socks. Then yes, I'd agree.
We could handle that other matter now. I'm getting close to that point.
Well, why don't you finish what you have here, then we'll take that up at our break.
May we respectfully request the court's guidance on the use of an exhibit?
Counsel, we've had this discussion.
Mr. Matheson, do you have any information regarding the amount of blood that was originally drawn from Mr. Simpson?
Calls for hearsay.
Overruled.
No personal knowledge.
Rephrase the question.
Do you have any personal knowledge of, or do you have any information regarding the amount of blood that was drawn from Mr. Simpson?
As phrased, no foundation for personal knowledge.
Overruled.
The only information I have regarding that quantity was what I heard during the preliminary hearing.
And that was from the nurse who drew it, correct?
Well, this calls for hearsay.
Sustained.
Do you have any reason to believe that the amount of blood drawn from Mr. Simpson was anything other than 8 milliliters?
Your Honor, that calls for speculation.
Sustained.
Hearsay.
Teams to you. We'll see you back here in about 15.
Completely irrelevant. What you're saying is that perpetrator, that's going to be the blood of the victim. So if what Mr. Blazier is saying is that that is indeed a true type B and not a BA, then this knife is completely irrelevant, because as we know for sure, none of these victims was a type B. Now, if what Mr. Blazier would like to argue is that this is actually the blood that's a BA type degraded to a B, that's fine. I don't know what he does with his inconsistent argument that the type B found under her fingernails was actually not a BA degraded, but a real B. That becomes internally inconsistent. So their position is revealed by their insistence on this piece of evidence to be both logically and scientifically ridiculous. There's no relevance because it was obviously not there at the relevant time. It was planted there by someone else. We also have a situation in the testing of this item that reveals that there's no PGM obtainable. Obviously, what we have is very degraded blood on this knife. The EAP came back B in one spot, and, excuse me, Your Honor, I'm talking fast because I know you want to get this done, and B inconclusive on the EAP marker. But there was no PGM obtainable from it at all, showing how severely degraded this blood is. So that, all of those factors put together reveal how irrelevant this piece of evidence, quote unquote, really is. I would like for Mr. Matheson to address further the scientific issues if the court would like to hear that concerning the significance of the degradation, the loss of the PGM marker. What is interesting in contrast is that the fingernail scrapings from underneath Ms. Brown's fingernails reveals we do have a PGM type that is consistent with her, which tends to further buttress the fact that the blood type EAP is a degraded BA. But on this knife, we have nothing. All we have is a type EAP that shows a B and a B inconclusive, no PGM activity on the blade of the knife, which would be the blood of the victim. So what does it have to do with this case? At a point in time after the metal detectors have swept the area, it's more nonsense, red herring is what it is. And under 352, it would be unduly misleading, confusing, and time-consuming to this jury to chase down yet another dead end that the defense wants to throw in their face. May I confer one moment, Your Honor? Yes, Mr. Darden points out further that it would take about 5 witnesses to resolve this. We would need the searchers who did the metal detector sweep. We would need Detective Payne, who received the tip. We would need the persons who found the knife. There's another 3 people who found it. And then the analysis of the knife by Mr. Matheson. We're talking about quite a lot of time to chase down something that is completely not only irrelevant but ludicrous in this trial.
Mr. Blazier?
I resent the notion that we planted this evidence. There were 4 people that have nothing to do with this case that we've talked to who found that knife.
I didn't hear that comment made, Counsel.
Well, I did. I'm sorry. They say it's not relevant because they don't want to believe it. It has blood on it that's consistent with the blood under the fingernails. That makes it relevant, whether they like it or not. It is relevant evidence, and everything that she said goes to weight. It should not go to admissibility.
All right. I'll make for the purpose of this particular item, the package of reports, Court's Exhibit number 10. All right, let me read it. We'll take a recess, and we'll see what we do with it.
Before we do that, I would like to make a record on the exhibit, if I might.
Counsel, you've had your opportunity.
Your Honor, I don't think we did that on the record, and I apologize if I've missed some step here, but I don't like to play a guessing game, and I'm sorry, and I apologize for that. But I don't know what you want. I thought that we had covered everything that we had talked about, and I'm asking as a courtesy for some guidance. That's all.
We'll stand in recess. Time sustain the objection, first on the basis of foundation, secondly on the basis of Evidence Code Section 352. Given the, at this point, speculative nature as to where this particular item came from, how it was found, how it was came to police attention at a date significantly past the relevant dates where these locations were previously searched, I'll sustain the objection. As to the exhibit, Mr. Blazier, the court's concern is the initial assumption as to the initial amount. What I'm saying to you and what I've indicated to you is that at this point, I don't think you have the foundation for it. At some later point in time, I suspect you will.
No, I thought that maybe that's what you were getting
Yes,
at. What I wanted to do, though, and is do that subject to connection. And obviously, I can make an offer of proof that the nurse testified at the prelim that it was 8 milliliters. And the people have been allowed to introduce test results from that blood vial subject to connection, and I'm simply asking for the same. Their exhibit boards were subject to connection as well.
All right. My problem, though, with this one, Mr. Blazier, is that it is in the form of argument, and since it is demonstrative evidence.
Actually, Your Honor, I have a plate to cover up that. I have a plate so that there's no text on it at all. Could I use it under those circumstances?
Well, let me see it. Since you've modified it since yesterday morning?
I'm sorry?
You've modified it since yesterday morning.
No, actually, I had a plate just in case there was a problem with that particular entry.
Works for me. You know, if you anticipate these things to begin with, Mr. Blazier, I mean, why do we have these pitch battles over things that you... Well, never mind. Never mind.
Your Honors, the court now will pursue its ruling as to the use of the
I
book
said
truck.
that could not be used given the way it was marked because I didn't think it was factually correct. All right?
But there are still some factual inaccuracies that I mentioned to the court yesterday, which I don't think the court felt you have to get to, such as the fact that the dates are, the
I thought all of
amounts
that-
were approximations. On the business records, they have a little squiggly.
No, I understand that.
And,
All right, given the modifications... I'm sorry, Mr. Goldberg.
And on one of them, it indicated that Mr. Matheson had removed blood on the 25th when it was Mr. Matheson had removed blood on the 25th when in fact it was Mr. Yamauchi.
I thought all the notations had been withdrawn from that.
Are all of them withdrawn?
I won't put anything up there.
All I saw was a test tube and amounts, is what I saw. I saw no dates, times, places, people.
I did have some tag. I'll only do what he agrees with, certainly. I won't do the one with,
Just out of curiosity, given the magnetic nature of that, how heavy is that?
actually, it's not too heavy.
Well, the amounts don't designate that they're approximates. And there is no designation of the amount that Mr. Matheson during his testing.
Mr. Goldberg will tell me how to make an approximate blank for that. I'll be happy to do it. I don't know how.
All right.
Approximations.
All right, any other comment, Mr. Goldberg?
Well, the problem with the amounts is that they're asserted to be definite. They're not approximations, and also there's no foundation from the witnesses as to how they measured them. We heard from Mr. Matheson how he made his estimations when he came up with an approximation that the blood vial contained 2 milliliters at a point in time that we know it had to have at least 3.8 milliliters. And from that, he concluded that he is at least has a margin of error of greater than, equal to or greater than 1.3 milliliters. So to put before this jury what is at this point an argument asserting precise numbers when we don't know how the measurement was made, we don't know under what circumstances, we don't know what the margin of error was on the measurements, is misleading. And also this doesn't calculate the amount of blood that stuck to the pipetters and the microcentrifuge tubes, which can be fairly considerable when you add it all up.
Mm-hmm. All right. Well, here's the thing, though. The court controls the order of proof. I'll allow this subject to a motion to strike. It's the same situation. The foundation for the blood itself, I've allowed subject to a motion to strike. I'll allow this, which is the same topic, subject to a motion to strike. Since all of this, this particular exhibit has been completely modified to take away all of the other notations other than the amounts. All right, let's proceed. Let's have the jurors, please.
Check on the photographs, I'm sorry. And we did not get the particular photographs the defense introduced in discovery.
All right, we'll take that up at the noon break.
Thank you.
We'll take that up at the noon break. Reflect we've been All right, record show reflect we've been rejoined by all the members of our jury panel. Mr. Blazer, you may continue.
Thank you, Your Honor. Your Honor, may I display the exhibit?
You may. Have we marked this yet?
I don't think we have.
11:39. that may be the max there, Mr. Douglas, on this one.
Mr. Matheson, I want to ask you just a few more questions about the blood vial. And I want you to assume again, hypothetically, that there was originally 8 milliliters of blood in that vial. You have that in mind?
Yes.
Now, your records indicate, the business records indicate that on June 14th, Colin Yamauchi withdrew approximately 1 milliliter, correct?
Approximately, that's correct.
And I'm afraid this is much too high. Can you reach that? Take off the 1 milliliter.
Mr. Cochran, for the purpose of this presentation, I would suggest we move this over here so it's at a workable level.
Your Honor, that's the only one that I can't reach.
Let's put it here. It'll be easy to work with.
Now, Mr. Matheson, do you agree that, following our hypothetical, that as of the 14th, after Mr. Yamauchi withdrew his approximately 1 milliliter, there would be approximately 7 milliliters left if you started with 8?
That's correct.
Now, the toxicology records that we talked about indicated that as of June 20th, there was 5.5 milliliters remaining, correct?
Approximately, according to the records, yes.
And there were no other withdrawals between Mr. Yamauchi's withdrawal on the 14th and when toxicology did their analysis on approximately the 20th, correct?
It's my understanding, yes.
So you would agree, would you not, that if that is the case, that there were approximately 1.5 milliliters of blood unaccounted for, gone from Mr. Simpson's reference to?
Argumentative, unaccounted for, Your Honor. Calls for...
Rephrase the question.
You know where that 1.5 milliliters went?
Assumes facts not in evidence, argumentative.
Overruled. Rephrase the question, though.
Would you agree that, according to your own business records, that if there were 5.5 milliliters of blood remaining on the 21st, and there had only been 1 milliliter taken out of that blood, and you started with 8, there'd be 1.5 milliliters unaccounted for?
Improper hypothetical.
Overruled.
Also argumentative, unaccounted for.
Sustained.
Missing.
Rephrase the question.
1.5 milliliters less in that tube than you would expect.
Approximately, that's correct.
Now, the next withdrawal that your records indicate is on the 25th, and that would be, I'm sorry, the withdrawal for toxicology, would you agree that the records indicate that that microcentrifuge tube, which holds 1.5 milliliters maximum, was taken and some of that was returned?
I'm sorry, I don't understand. Do you mean some of the tube or some of the blood in the tube?
No, let me do that one again. The blood vial that you've examined that we saw in the picture has that microcentrifuge tube back in it, correct? With the vial.
Yes, that's correct.
And there's still some blood in that microcentrifuge tube, correct?
Yes, there is.
And that originally, as a maximum, would have held 1.5 milliliters, correct?
Correct.
And according to Mr. Yamauchi's notes, he estimated that there was approximately 3/4 of a mil left, correct?
That's what he recorded, yes.
Now, would you agree that, therefore, toxicology would have used approximately, at a maximum, 3/4 of a milliliter?
At a maximum, yes.
Now, if we remove 3/4 of a milliliter, we're now down to roughly 6.2, 6.3. Would you agree?
Approximately, yes.
Now, the next withdrawal was Mr. Yamauchi on the 25th for purposes of ABO typing and other serological typing, correct?
Yes.
And his records indicate that he took approximately 0.75, correct?
That's correct.
Now, I'm going to take down 0.70 to be conservative, even though it was 0.75.
I object to that being conservative. That's an underestimation.
Sustain, rephrase that.
Well,
That's argument, counsel.
Okay.
Just take it down.
I'm trying to figure out how to get to 0.75 here. This is approximately 0.05. Does that look approximately 0.05? Very small amount, isn't it?
In relation to your rest of your bars, yes, it is.
And if you remove 0.75, according to the business records that you referred to, that would leave, at that point, approximately 5.5, correct?
Yes.
Now, you indicated at that point that you took, there was a small thread of just a couple of drops by Mr. Yamauchi on about the 27th, correct?
That
The
misstates
thread.
testimony.
Sustain, rephrase the question.
On the 27th or thereabouts, Mr. Yamauchi took an extremely small amount for a thread for electrophoresis, correct?
He prepared threads for electrophoresis, that's correct.
And that requires almost nothing, correct?
Well, the threads themselves require very little, but you do have loss in what's in the spot plate and what's in the pipe header.
Okay. Now, the defense was allowed to take 1 milliliter in September, correct?
Yes, that's correct.
And there are records of that, are there not?
They were given approximately 1 milliliter, that's correct.
Now, you indicated that at some point you took out some blood, but the amount is not reflected in any business record anywhere.
That's correct.
So as far as the business records are concerned, in terms of what's written down when there are withdrawals, when there is an amount indicated, under the hypothetical, if, incidentally, have we taken off everything to account for all of the withdrawals where there is an amount written down?
I believe so, yes.
Okay. The only thing remaining is the one that you didn't write the amount down, correct?
That's correct.
Now, assume hypothetically again that on January, when you measured the quantity of blood left in both the reference tube and the microcentrifuge tube, there was a total of 2.6 milliliters. You have that assumption in mind?
Going off that assumption, yes.
Would you agree that under that hypothetical, following just the business records of withdrawals, that as of January of 1995, there would be a total of approximately 1.9 milliliters of blood unaccounted for? Unaccounted for,
Object to the phrase unaccounted for as
Sustained.
argumentative.
unaccounted for by the business records.
Well, it's still argumentative.
If you're referring to only those that are specifically recorded and not taking into account what is left in pipettes, but actually what was delivered in certain areas, then that's a approximation, yes.
And by your earlier testimony in terms of the number of swatches, if you could get 150 swatches out of 1.5 milliliters, you could get correspondingly more swatches out of 1.9. Would you agree with that?
Yes, given the hypothetical.
Now, the only other withdrawal that we know about that you've testified is the one that you did where you did not write down any particular amount, correct?
As I'm sitting here right now, right, that sounds correct.
And you indicated that you started with a half to 1 milliliter? That's your best recollection?
I would say I used a minimum of a half mil, and it could be as high as 1.
And according to what you had told us before, you don't recall it now, but you put it back.
Well, I remember making that comment,
I'm sorry,
yes.
what you didn't use.
That's correct.
And you used approximately 6 to 8 drops?
That is the amount that would actually be consumed in the test. That is not the amount that would not make its way back to the vial.
Okay. There are other amounts like clinging to the side of the or of whatever the pipette or whatever you use to remove the blood, correct?
That's correct. That's why I gave the low end of being a 0.5 milliliter.
Okay. And you you indicated, I think, a couple days ago that rough estimate on what might have been caught on the side of the tubes was 1/4 of a mil, 0.25.
That's a rough approximation, as possible.
Now, and the 6 or 8 drops accounts for approximately how much?
As far as,
How many milliliters?
well, if we're using 20 as an approximation of the number of drops per mil, that's a little less than half a milliliter.
A little more than 1/4.
Yes.
So if we say, therefore, then approximately 1/4 to half is lost on the sides of the containers and is used up by you, and you took out 1 to start with, that would reduce the total amount of blood in the vial by a milliliter. Do you agree?
In that instance, yes, that'd be an approximation.
And if we remove a half a milliliter, we have now accounted for all of the known withdrawals that are recorded anywhere from Mr. Simpson's reference sample, correct?
That's argumentative because it was based on the hypothetical.
Sustained.
Hypothetically, under our hypothetical we've been talking about, we've accounted for everything that, under the hypothetical, was taken out of Mr. Simpson's reference tube, correct?
Well, you've accounted for everything except for, we gave the situation of the approximate amount that would be left in the vial that I worked on, or the centrifuge tube that I worked on. We have not taken into account, excuse me, every other transfer device or measuring device that is done by other people. An example being when we gave a milliliter to the defense on the date, I believe it was September 30th, there is going to be some retained in that. We delivered approximately a milliliter, but there's going to be a little bit more. And every time you open the cap up, there's blood clinging to the inside of the cap. You set that down normally with a Kim wipe, blood is going to be lost into the Kim wipe at that point. So there's constantly little bits that are going out just in the process of handling, and that has not yet been taken into account.
Now, these would you say approximately 1 milliliter was removed? That means it could be less, too, correct? All of those approximations could be lower.
Well, in relation to the one that Mr. Yamauchi did, on my transfer, the amount that I provided for the defense, that was done with a calibrated pipette. So 1 milliliter was delivered, then plus whatever adhered to the tips and to the vials and that type of thing would have been not returned.
But with the other entries, withdrawals that your people did, those are estimates and could be slightly less than a milliliter, correct?
They are approximations, yes. They could be either slightly less or slightly more.
So would you agree, under the hypothetical, that as of January, taking into account all of the other withdrawals that we've talked about, there is still approximately 1.5 milliliters that is not accounted for from the records and from your recollection of the withdrawal?
Argumentative as to accounted for.
Oh, well.
I would say that it is probably less than that because of the other factors I mentioned, like losing it in the handling, opening the tube and the pipettes and that type of thing.
Mr. Matheson, I want to ask you some questions about the blood found under Nicole Brown Simpson's fingernails. Do you have that in mind?
Yes, I do.
Now, is it true that in homicide cases, particularly homicide cases involving some form of assault, physical assault, it is routine to collect the fingernails of the victims?
Yes, it is.
And the purpose for that is that the victim, possibly in an assault case, might fight back and might scratch someone and therefore get biological material like blood from the perpetrator under the fingernails, correct?
That's one of the reasons for collecting them, yes.
And there's even more reason to do that if you have an assaultive situation where the victim has defensive wounds on his or her hand indicating a possible struggle.
Argumentative beyond the scope.
Overruled.
No foundation for this witness's opinion.
Sustained.
In any event, those are routinely taken for purposes of determining whether you can identify a perpetrator's blood under a victim's fingernails, correct?
Asked and answered.
Overruled. Is that correct?
Yes.
Now, as I understand it, that was done in this case, and you conducted an examination of the scrapings from under the fingernails of Nicole Brown Simpson, correct?
That's correct.
And there were scrapings taken from both hands under all the fingernails on each hand, correct?
Yes.
And the numbers that we've used to designate those are 84, A, and B, correct?
Yes, that's correct.
And that's the evidence item number that was used and the number that you've used in your lab for your testing purposes, correct?
Yes.
And 84A is which hand?
Referring to my analyzed evidence report that lists those items, 84A is the left-hand scrapings, 84B is the right-hand scrapings.
And the test results that you got from running an EAP test were that the blood under those nails on both hands was a type B, correct?
That's what the results were, yes.
And there is no one in this case that you have identified that has an EAP type B, correct?
That's correct.
Mr. Simpson doesn't have an EAP type B, does he?
No, he does not.
So would you agree then that if your test results are accurate, that there is blood under Nicole Brown Simpson's fingernails from someone other than Mr. Simpson?
If the B is an actual B, yes, that's correct.
And that's the results that you reported out, was a B, correct?
That misstates his report and his findings.
Overruled. That's correct, along with a explanation alternative.
Mr. Madison, let me show you People's 218. Now you testified that was your analyzed evidence report, stating the results of your testing on the fingernails, among other things?
No, it is not.
There's another document that is actually your report, correct?
No, this is a report on a completely different set of items.
Have you been shown your report on the fingernails?
I have that sitting in front of me in my notebook. It isn't what you handed me.
document marked, please. A 3-page document titled Analyzed Evidence Report.
1140, Mrs. Robertson? All right, 1140, Mr. Blazer. Why don't you compare that with what Mr. Matheson has in his notebook?
Dated 9/8/94.
What,
Let me, I thought that was the other 3-page report.
I think it was 218, Your Honor.
That's what we just looked at.
Mr. Matheson has 218, he indicates that is the wrong report.
Oh, no, what I have in front of me is 2 pages that are marked as 216 and a 3rd page that is 218. It's a mixture of my 2 sets of reports.
All right, why don't you take a look at that, Mr. Blazer? They appear to be paper clipped together. An unusual clerical,
I think maybe, probably accidentally, we got reports mixed up yesterday or day before.
Well, I think there's one report that only has one.
I'd like to still have this marked as 1140.
what is it, Mr. Blazer?
It is an analyzed evidence report dated 9/8/94.
All right, so marked. Proceed.
Mr. Matheson, let me show you a document titled Analyzed Evidence Report dated 9/8/94. That is your complete report for the analysis of these items, including the fingernails, correct?
It is a copy of it, yes, with some areas that have been blacked out.
Now let me show you Prosecution Exhibit 218. What is that?
This is the 3rd page, or a copy of the 3rd page of that analyzed evidence report.
And that was not provided to you at the time you were asked to testify about your report by the prosecution, was it?
It's vague and also not relevant.
Sustained.
Have you testified about page 2 of that document at all yet in this proceeding?
Not relevant.
Sustained.
Take a look at page 2, please, for me.
Okay?
Now,
And when you say that document, are we talking about 1140?
yes. When you do a test, such as the test that you did on the fingernails, you have what are called work papers, correct?
There are electrophoresis worksheets, yes.
And those are documents that you fill out while you're doing the actual bench work. You write down your observations of what you think the results are and how the test is done and that sort of thing, correct?
Yes, it is.
And after you do that, you prepare a final report from those bench notes, correct?
Actually, the bench notes of all the different electrophoresis runs that are associated with the case then are placed onto what we call a summary sheet, which brings all the results from all the tests together into one place, along with some of the observations. Then the information from the summary sheet is then transferred onto the final report.
And the summary sheet is your final reading of typing for tests that you've done, correct?
It lists, yes, the final readings.
Now, I'd like to display this on the demo. We need to.
right now.
What's the basis? The legal basis?
It contains inadmissible evidence, and that's confusing. Inadequate foundation. I can't articulate it.
All right, let me see, counsel at the sidebar, let me have a, let me see the document. All right, Mr. Blazer, which chart is this?
I think it's 302.
No. Well, when it comes down, we'll take a look at it.
Mr. Matheson, you've seen that chart before. You've testified about it, correct?
Yes, I have.
And in that chart, it's indicated, this, by the way, who prepared this chart?
It was prepared by the DA's office.
You didn't prepare it, did you?
No, I did not.
Item number 42 is the sample taken from the area under Nicole Brown Simpson, correct?
Yes, it is.
And one of the arguments that the prosecution is using to say that your test results on the nail scrapings are something other than they are.
Counsel, you need to rephrase that
Okay.
question. All right, and for the record, this is People's 202, the chart.
202. In your report that you prepared after your analysis, you determined that item 42 was inconclusive, correct?
That's correct.
And what's the scientific definition or meaning of the term inconclusive?
Inconclusive to me means that there's not a conclusive decision or conclusive statement that can be made about the results.
Doesn't it mean scientifically that you can make no statements about the source of the stain when it's inconclusive?
Well, I don't report a inconclusive result. So yes, I would not make a statement about the source based on an inconclusive result.
Now, but in this case, you're asking to make some conclusion about the source of the stain of 42, even though it's an inconclusive, aren't you?
That misstates the evidence.
That's argumentative, the way it's phrased.
Now, on your final report, when you reported your findings on 84A and B, does your report say B asterisk?
No, it does not.
It says B, doesn't it?
Yes,
It says B for both the left hand and the right hand, doesn't it?
that's correct.
Now, do I understand that it's your position now from your testimony that you're asking that, or you're stating that the B is something other than a B?
That misstates the testimony, too.
Overruled.
I am not saying that the B that I observed is anything other than what I am seeing, and that's the two bands in the B area. I'm merely stating that there's possible other explanations in addition to it being a type B.
Now, all of the other serological results that you've testified to, you testified that your results are accurate, or you believe they're accurate, correct?
That also misstates the testimony.
Overruled.
I believe all of my results are accurate.
Is there any other test that you did where you got a reading or a result that you reported that you're asking us to accept as being inaccurate, except that one?
I'm not stating that this one is inaccurate. I'm just stating that there is a alternate explanation for what I'm seeing on the gel.
Okay, so it looks like a B, doesn't it?
Yes, it does.
And what you're saying is that, in your opinion, sometimes something else can look like a B that isn't a B, correct?
That's correct.
And that's a BA, correct?
That's correct.
But in this case, you saw a B, didn't you?
Yes, I did.
Now, how long has the Los Angeles Police Department been using the EAP system?
I believe that we have been running EAP as part of a system for, well, it was in existence when I started doing my testing, which was in 1982, and I believe that it had been being used for a few years before that, 2 to 4, 6, something like that.
Can you give me just a real rough estimate of the number of cases that you've worked on where you've done an EAP test?
I would like to check my record and see if I made a estimation of that.
Sure.
Okay, the chart that I prepared of tests that I run did not include the EAP. I can give you a rough estimate based on some of the other markers that I've done.
Okay.
And I would say that I have run somewhere between, I don't know, probably 1,500 and about 2,000 items for that marker.
And an EAB type B is a fairly common type, isn't it?
I believe it is, yes.
So can you give us, do you know what percentage of the population is a B?
I'd have to check another chart that I have.
Why don't you do that?
According to our statistics that we use, it's approximately 50% of the general population.
And would it be fair to infer from that that of the approximately 1,500 times you've done this test, roughly half of them would come back EAP-B?
That's correct.
And have you testified in court before about EAP results that have come back as a B?
Yes, I have.
And of course, in these approximately 750 cases, I assume you've written reports that have said, I tested it, looks like an EAP-B to me, correct?
Yes.
In all of those reports, do you write down, you know, it could be a BA?
Not in all those reports, no. I do include that disclaimer when the EAP is a source of elimination or exclusion in a sample.
Have you testified in court where an EAP-B happens to be the type of the suspect and also the evidence you tested that it's an EAP type B without giving that disclaimer?
Like I just mentioned, I will put that it's a B unless it's an exclusion of some type.
Can I take that as a yes? You have so testified in cases that an EAP-B result is a B when it incriminates a defendant without saying that it could have been a BA?
Yes.
Now, as I understand your argument that this B that you found is something other than a B is based on two things. One, scientific literature.
Mr. Glazier, would you,
I'm sorry?
excuse me, would you rephrase the question, please? Can you start out your argument that?
You testified yesterday that one of the reasons you're here to say that this B might have been a BA is because of the scientific literature, correct?
That's one of the things, yes.
And one of the other things is that that you testified to, is that because sample 42 has the same findings or similar findings as 85, and since 42 appears to have come from the victim, then therefore the blood on the fingernails may have come from the victim as well. Have I got that right?
No, I believe the other reason that I use is personal experience in both this case and other cases.
Did you not use the example of 42 as well?
Yes, but I don't think that was your question on this particular instance.
Have you ever written any papers or published anything on EAP systems?
No, I have not.
Have you ever a couple of rare types that are almost never found?
There are many rares, yes.
For all practical purposes, the field is limited to an A, a B, or a C.
Correct.
Now, if someone inherited the B characteristic from both parents, then they would appear as a B.
That's correct.
And if someone inherited the A characteristic from both parents, they would be an A.
That's true.
And if someone inherited an A from mom and a B from dad, they'd be a BA.
That's correct.
And that's basically how it works. And the same thing would apply if you got a C from one of your parents.
Yes.
Now, the way you determine what an EAP type is by looking at the bands on the gel to see where they stopped when you turned the current off, correct?
That's one of the factors in this, yes.
And you've seen these slides before. We looked at these yesterday. You recall that?
Yes, I do.
And the slide that's up there now is your electrophoretic for run number 7310, correct?
Yes, it is.
And does that appear to be an accurate picture of that slide?
Yes.
Now, I might indicate that we talked about this yesterday. Sometimes these slides, when you scan them in the computer, don't pick up all of the nuances of the banding patterns, correct?
Well, that's correct, yes. Some things may not show up as well being projected like this and looking at the original photograph.
And we have the original photographs, so we can look at those at some point, correct?
Yes, I have them here.
Now, could we go to the next slide, please? Now, I've drawn a box around a lane in the middle of this electrophoretic, correct?
Yes.
And this is what's called a standard. In other words, you knew what this was before you tested it, correct?
That's correct.
And you knew this was a BA.
That's true.
And the reason you do this is so that you can look at your unknown evidence that you're testing and, well, let me rephrase that. The reason you do this is because you want to see if the test worked okay. If this comes back the way you expected it to, that's a good indication the test worked.
That's one of the reasons, yes.
Now, this particular lane in the middle, this BA standard, came back the way it's supposed to, didn't it?
That's a typical looking BA, yes.
And let's go to the next slide. This slide C. C. Now, I've drawn boxes around the various bands in that standard. And there are 4 bands, correct?
Yes, there are.
Go to the next slide, please. Now, I've removed the picture from the background so it's a little bit easier to see. Those 4 bands are called B1, A1, B2, and A2, aren't they?
That's one of the designations for them, yes.
We do the next slide, please. Now, I've colored them in so that they're a little bit easier to distinguish. Now, if someone is an A, they're going to have 2 bands located at A1 and A2, correct?
Yes,
That's what you would expect to see.
that's correct.
If somebody is a B, you would expect to see 2 bands, one at B1, one at B2, correct?
Yes,
Go to the next slide, please. Now, would you agree that if you saw that particular banding pattern depicted on slide F, that's a BA?
it's a rough graphical demonstration of it. It has a little bit of a problem in that it doesn't indicate the intensity differences in the bands.
Okay, well, let me ask you about that. You talked about how the intensity of a band might affect the reading, correct?
It definitely does affect the reading, yes.
Now, C bands, which are not on this diagram, correspond in position to the B bands, don't they?
Yes, they do.
So that you can have a C with a banding pattern that is at the same spaces on the electrophoretic as the B, correct?
That's correct. The 2 C bands run the same distances of the B bands.
And one of the ways that you tell the difference between a C and a B is by the differences in intensities of those 2 bands, correct?
Well, not one of the ways. The way
The
is
way.
to tell the difference, look at the difference in the intensities or brightnesses of the bands.
Right. Now, if you're talking about comparing an A and a B, however, none of those bands overlap, do they?
No, they do not.
So if your universe is limited to an A or a B, band intensity is irrelevant, correct?
No, that's not true.
What is the effect of band intensity on telling the difference between an A and a B?
Well, as far as telling the difference between the two, I'm sorry if I misunderstood your last question. It doesn't make a difference. It does make a difference when evaluating the sample and whether or not you call it, because you
Okay.
expect to see intensities in certain ways as far as the result goes.
Okay. But as far as distinguishing an A from a B, it's irrelevant.
The intensities, that's correct.
Now, if we have the next slide, please. Now, this is the pattern you would expect to see with a type B, correct?
Again, except for the fact that the B2 is the more intense and would be larger, and the B1 is less intense.
Okay, but in terms of relative position, that's correct, isn't it?
That's true.
Next slide, please.
Hold on, this one is which?
That was G. This is H.
All right, you need to, for the purpose of the record, let me know which one
Okay.
you're bringing up.
And correspondingly, the column on the right, that's what an A would look like in terms of the position of the bands.
Yes, that's true.
Next slide, please. This is I. Now, Mr. Matheson, this is a picture of the electrophoretic that contains the fingernails, is it not?
Yes, it is.
Now, this has a lot of little dots and things on it that are extraneous results that sometimes come up in these tests, correct?
That's correct. The dots, the round dots that you see are not related to the EAP or the information from the samples.
And the scientific term for that is schmutz, isn't it?
Actually, I don't think I've heard that term, but
Okay. Mr. Chef told me that. Next slide, please. This is J. Now, I've circled or boxed 3 lanes of that electrophoretic, correct?
yes, you have.
And the lane on the right of the box is your BA standard lane, correct?
That's correct.
And the 2 lanes next to it, to the left, are 84A and 84B, correct?
Yes.
Next slide, please. Now I'm going to isolate just those 3 bands, correct?
Yes.
And that's slide K. And let's go to L. I'm going to make it a little bit bigger so we can look at it a little more carefully. Now let's go to M. Now I've drawn boxes around the bands in their approximate positions, correct?
The approximate position, yes.
Now let me back up a little bit. When we saw the picture of the electrophoretic, it looked like it was a little bit bowed down at the sides, correct?
Oh, it was quite a bit bowed
Quite
at
a
one
bit.
point, yes.
And that happens sometimes as a function of the way the test is done, correct?
Yes.
It doesn't invalidate the test, does it?
No.
Because you can adjust the bow to figure out where the bands are and essentially straighten it out, in essence, to figure out which band you're looking at, can't you?
You can sometimes, yes.
Now, the bands that I've boxed there are slightly out of line with the standard because the electrophoretic was bowed a little bit, correct?
Yes.
And would you agree that the boxes that I've put around the bands are the bands that you read when you did this test?
Well, that's vague as to the bands that you read.
Overruled. Do you understand the question, sir?
Yes.
All right.
Now, I'm sorry.
In the case of 84A and 84B, those are 2 bands that are visible. That is not the only parts of that area that are taken into account.
But those are the bands that are there.
That's correct.
And next slide, please. Now we're taking the background out to give it, so you can see it a little bit better. That's N. Now let's do M.
I'm going to object at this point on the grounds previously stated that I
Noted.
thought were going to be clarified.
You were going to ask a question regarding the alignment of the boxes.
Oh, I'm sorry, I thought I did. Mr. Matheson, on, this is slide O. I've indicated that the bands from the fingernails are bands B1 and B2, and that's the bands that we saw on the electrophoretic, correct?
For those items under the 84A and 84B, that's correct. They're roughly where they are. Don't take into account the curve, and they don't take into account the intensity differences.
Right. And if we adjusted the curve, those bands under 84A and 84B would line up with the standard B bands in the standard BA, correct?
That's correct.
Next slide, please. Now, and as you read in your report, the fingernail, I'm sorry, as you reported in your report, your reading of that test was that both fingernails from both hands were type B, correct?
That's correct.
And that was slide T. P. Let's go to Q. Now we're back to our standard BA in Q. Let's go to R. Let's go to S. Now, part of your testimony the other day concerned the manner in which a BA can degrade, correct?
That's correct.
Now, if you have a BA, you would have the banding pattern that we have up on slide S, correct?
Again, not taking into account the intensity differences, but that's the locations of the bands.
Now, I want you to assume, for purposes of hypothetical, that the degradation that occurs when a BA degrades involves bands disappearing from the top down.
Improper hypothetical, no foundation for it.
Sustained. Rephrase the question.
Mr. Matheson, let me ask you about some of the scientific literature. You referred to an article by Grunbaum and Zajac in your direct testimony. You recall that?
I was directed to that, yes.
There's other literature on the EAP systems, correct?
Yes.
And you're familiar with that other literature, are you not?
I've read some of them, yes.
And you were provided a copy with a number of different articles the other day, were you not?
No, I was not.
No. Are you familiar with an article by Dr. George Sensabaugh entitled The Utilization of Polymorphic Enzymes in Forensic Science?
I'd like to see it, please.
Sure.
I've seen this, yes.
And have you relied upon that in the way you evaluate the EAP system?
It's overbroad questions raised.
Overrule.
I have read this article, and there is information in it that regarding the EAP in general, is one of many references that I have referenced in relation to the EAP system.
So it's one that you have considered and referred to.
I have considered some of the
It's
information.
vague as to considered in what, in rendering opinion.
We'll get there in a second.
Did you do any research at all before your testimony on the rate at which, according to the scientific literature, a BA degrades to a B?
I have done some reading on that, yes.
What things did you read?
Well, there was 3 or 4 articles that I read that related to degradation of EAP in general, and many of them that reference one particular way that it degrades.
What articles did you read?
I could, I think a reference to give you a couple of them.
Yes.
As mentioned earlier, one of the ones that I've read is this article that you presented before me. I also read an article entitled Erythrocyte Acid Phosphatase in Blood Stains by Raxel and Eames.
Let me show you an article. That's it, isn't it?
Yes, it is. And I also referenced a book called the Source Book source book in forensic serology, immunology, and biochemistry. And I also read portions from a book called Forensic Science Handbook by Richard Saperstein.
Are you familiar with a technical note by a T.E. Yeshion, Y-E-S-H-I-O-N, titled Thermal Degradation of Erythrocyte Acid Phosphatase Isoenzymes in a Case Sample?
I read that one the other day, yes.
And this, I'm handing you appear to be that article.
Yes, it appears to be.
And have you reviewed and considered an article by R.A. Fisher and Harry Harris titled Studies on the Separate Isoenzymes of Red Cell Acid Phosphatase Phenotypes A and B?
And I'd like to see it, please. This one does not look familiar to me.
Let's take a look at this.
Now, other than the Grunbaum article, incidentally, let me show you a copy of that and ask if this is the article that you testified about the other day.
Yes, it appears to be.
Other than the Raxall article, the Yeshian article, the Grunbaum article, and the Sensabaugh article, are there any other scientific articles that you have reviewed specifically to look for how a BA degrades
It's vague as to time.
Overruled.
in preparation for this case?
I believe I mentioned two other references, something that is commonly called source book and a textbook by Saperstein.
And I was talking about articles devoted to that topic specifically rather than textbooks.
Oh, I'm sorry. To the best of my recollection, that's it.
Okay. What do those articles say about the rate at which a BA degrades?
Rate meaning the amount of time it takes? Or
No. Which bands disappear first?
Most of the articles make reference to the fact that degradation does in fact occur, and that as a rule it tends to go from the anodal or the faster bands down towards the cathodal or slower bands.
Would you agree that those articles stand for the proposition that at the first stage of degradation you lose the A2 band?
It's overbroad as to those articles.
Sustained.
The articles we've been talking about.
It's still overbroad.
Sustained.
Sensabaugh, Zajac, Yeshian, and Raxall. Those four articles. Would you agree that the results of their scientific tests are that the first thing to disappear is the A2?
Assumes that they all did scientific tests, background evidence.
Overruled.
They do tend to point out that the most labile, or the first one to go, is in fact that fastest
Next
A2
slide.
band.
I'm sorry, next slide. This is T. So after that first stage of degradation, your BA is going to look like the right-hand column of slide T, according to the scientific literature, correct? This scientific literature.
According to those articles, that's the degradation route that they have seen.
Now, those articles also state, do they not, that the next stage of degradation is you lose the B2 band.
Well, it assumes that there's only one degradation route back on Memphis.
Oh, we'll this is in reference to these articles.
Yes.
That's the general route that those articles reference, yes.
Okay, the next slide, please. This is what? U? U. So would you agree, would you not, that these articles indicate that the next stage of degradation you would see, if you had a BA that was degrading, you would see two bands, the B1 and the A1 band?
Under the conditions that those studies were run in, yes, that is the general route of degradation.
Now, those studies further indicate, do they not, that the next thing to go when it degrades is the A1 band, correct?
That's the general route of that form of degradation, yes.
Next slide, please. The B. So therefore, according to these articles, a BA that's degrading will ultimately, before the last band disappears, have the B1 band there, correct?
Again, according to the conditions that those samples are treated and under the conditions they are run, that is the degradation route that's referred to.
Agree that under that degradation route, you never have the pattern of a BA that's degraded that has both the B1 and the B2 bands without the A1 band.
Again, given the things I mentioned before, the condition of the samples in those studies, and the system they used for identifying it, that is true.
And in this case, your test results showed both the B1 and the B2 band without the A1 band, didn't they?
That's correct.
So under this scientific literature, if this BA was a degraded, if your B under the fingernails was a degraded BA, it wouldn't look like the results you got, would it?
If my sample or the samples that I analyzed were under those conditions in those studies and run in the same way, that's correct.
Can you cite me to a single scientific article that states that the degradation route taken by a BA when it degrades would ever get you to the point where you're going to have a B1 and a B2 without the A1?
And we're talking specifically about articles at this point.
Yes.
No, I cannot.
I think you said also, let me turn that off now. Now, none of those articles that we've talked about, the reason cited in those articles for doing these studies is to find out how a BA degrades, correct? So that was one of the purposes of all these articles.
Well, it's known that it does degrade, so yes, the purpose of those articles, potentially among other things, because they include other bits of information, is to determine one of the ways that a EAP will degrade.
And all of those articles talk about you could misinterpret a BA or you could misinterpret a BA for a B if you made a reading based on just that B1 band at the end, correct?
That's correct.
And they all say that, therefore, you shouldn't make any reading at all if all you have is one B1 band, correct?
That's correct.
But they say also that you will not have a mistyping where you have a B1 and a B2 band, because that would not be a degraded BA, correct?
I don't believe they all say that, no.
Can you show me one that doesn't say that?
It's going to take me a few minutes to look. I believe they say that are things that may happen, but...
Well, Counsel, let's move on. We're not going to sit here and read articles.
They do say that you can accurately read a BA and a B as long as there are two bands present. In other words, you can read a B if there are two bands present accurately, correct?
It's incomplete as to what conditions.
Sustained. Actually, when you say they, I think you need to specify which articles.
Do any of the articles say that you should not call a B where you have both the B1 and B2 bands?
No, they don't.
Do they all say that you shouldn't make any call at all if you only have one band?
It's my understanding, yes.
Now, you also testified that item 42 had the same appearance, or the same reading, as the fingernails, correct?
No, I don't believe I said they had the same reading or the same appearance.
we go back to slide A? Now, you recognize slide A up there as being the one we were talking about with a standard?
Yes, I do.
Would you agree that the lane next to the standard that we used, in fact, why don't you go to the next slide, slide B, that the lane just to the right of the standard lane is item, I'm sorry, actually it's to the left of the box is item 42.
Yes, adjacent to the other standard.
Now let me show you a photograph. Does this appear to be a photograph of that same electrophotogram?
Yes, it does. It appears to be an enlargement of it.
And item 42 appears in that electrophotogram as it does in the slide on the projector, correct?
Well, it's in the same location, and it's much easier to read in this photograph.
Now you can pick up a little bit more in the photograph than you can on the slide, correct?
Object to the phrase a little bit more.
Rephrase it.
You can see some very, very faint banding patterns under 42 that doesn't completely show up in the slide, correct?
That's correct.
Maybe we could try to put this on the Elmo. Illustrate this.
I think that's when we may have to have both up and have the jury look at the blow-up.
That's fine. Can we try this?
Well, yeah, I've tried, but I'm just trying to save some time here.
In fact, let me... Okay. We can see a little bit better this way. Would you agree?
A little bit better.
And would you agree that the lane for item 42 appears to have three very faint bands corresponding to B1, A1, and B2? Very faint.
Well, the B1 and B2, I believe I can see what are banding areas, very kind of fuzzy, difficult to read. There is kind of a brightish cloud in the A1 region.
And the photograph is 1141 A1. Now the very faint, can you see behind you on the screen up there? The very faint fuzzy A1 band is what I've got the light on, correct?
Well, that misstates the evidence.
Well, right back there.
Well, there is some fluorescence in that area. It's not even really what I would call a band.
It's not, and that one of the reasons that this was an inconclusive is because those are not sufficiently well-defined bands to really make a type on, correct?
Those is overbroad. Which of
The faint markings you see in lane 42.
It was called inconclusive, right, because the bands that I visualized in there just were not what I would call clear-cut bands.
And let me show you a photograph of the fingernail slide that appear to be a similar photograph.
Yes, it does.
And this would be 1141 J1. And I'd like to put both of these on at the same time, if I could. Now, you see the two photographs that we have on the projector.
Yes, I do.
And the 42, again, is the one that I have the laser light on now up on the big projector. Can you see that behind you?
I'm sorry, can you repeat the question?
Yeah, the light that I'm using on the large projector up above you is the 42 lane, correct?
Yes, it is.
And the lanes over here, oh good, we've got the arrow. Can we move the arrow over to 84A and B? Right there. Those are the banding patterns from the fingernails, correct?
Yes, that's correct.
And could we put an arrow over by 42 as well? Can you affix one there? Would you agree that the banding patterns for 84A and B are much more distinctive than 42?
Yes.
And that's why you read 84A and B and did not report anything other than inconclusive for 42.
It's one of the reasons, yes.
Print of items 42 and 84.
What was the printout?
It was the two electrophoretograms of 42 and 84 side by side with arrows.
Now, your testimony the other day about 42 was to the effect that since 42 was preserved under similar conditions to 84A and B, therefore you can draw some kind of an analogy between the results of 42 and the results of 84, correct?
States of testimony.
Overruled.
I believe environmental conditions and the like was one of the things that we mentioned that is used in the total consideration of everything.
Now, one of the photographs that you looked at of Nicole Brown Simpson showed one of her hands under her body and one of her hands up exposed to the air, correct?
Yes.
So those two were not under the same conditions in terms of drying or being in a pool of blood, were they?
Not exactly the same, no.
And would you agree that if you follow the scientific literature that I've shown to you and that you've reviewed, that the blood under Nicole Brown Simpson's fingernails cannot be a BA?
That's an improper hypothetical.
Overruled.
I'm sorry, could you read that or repeat that, please?
Would you agree that under the scientific literature that we've reviewed here, that the blood under Nicole Brown Simpson's fingernails cannot be a degraded BA?
If you look strictly at the literature and if the conditions under the fingernails are the same as the way the studies were done in the literature and the technique used to identify it was the same as that I used in my testing, then it does not follow that degradation route. That's correct.
And if that's true, then it has to have come from somebody else, correct?
Improper hypothetical.
Overruled.
Given all of the considerations that I mentioned, they would all have to be the same. And if, like I said, in fact, it did follow that same degradation route, then it would have to be a B and it would have to come from somebody else.
Now, if you have test results that you think might be wrong or ambiguous, what are you supposed to do as a scientist?
I would not report them if they are wrong or ambiguous.
If you thought that the results were wrong, would you redo the test?
Depends on what other tests were available to me.
Now, looking at EAP, well, if you do a PGM test or a DNA test, you're not looking at the same things as you're looking at an EAP, are you?
You're potentially looking at the same thing, but there are other factors. That's correct.
Nothing that you do other than an EAP test is going to give you an EAP reading, correct?
Oh, that's correct, yes. I mean, only an EAP test is going to give you an EAP result.
So the only way that you could double check that EAP test would be to do another EAP test, correct?
Well, theoretically, if they knew what caused the EAP type at the DNA level, you could do it that way. I don't believe there's a standard test for that right now. So the only way to reconfirm that result would be to run the exact same test again.
These fingernail scrapings were sent back to you by the Department of Justice for the purposes of doing another EAP test, weren't they?
That misstates the testimony. Seems
Sales
to
tax
have none.
sustain.
At some point, you sent them to DOJ and they sent them back, didn't they?
Yes, that's true.
What was the purpose for them sending it back?
Because it's our evidence. The evidence belongs back here when they're done completing it so that it could become part of the rest of the case.
Did you ever consider doing a retest of those fingernail scrapings, an EAP test, to see whether your original results were wrong?
Did I consider it?
Yes.
I considered it, yes.
You wanted to do it, didn't you?
I felt that there was other tests that could give more information. I did not want to consume any more of the sample just to repeat the exact same thing again.
So you've done no retesting to demonstrate whether this EAP is anything other than a B or someone other than Mr. Simpson, correct?
There has never been any other testing. I have not repeated or done any other EAP testing. That's correct.
No further questions.
All right, ladies and gentlemen, we're going to take our recess for the morning session. Please remember all of my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't allow anybody to communicate with you. Do not conduct any deliberations till the matter has been submitted to you. We'll stand in recess till 1 o'clock. All right, Mr. Goldberg, you had some comment or concern regarding discovery matters?
Yes, Your Honor. On the photographs that counsel used today of the blood vial, I do not believe that we were provided those in discovery. We have another set of defense photographs of the blood vial that we do have. Mr. Scheck tells me that he thinks that it's possible that the photographs that they use could be people's photographs. I did not have an opportunity over the noon hour to verify that, so at this time I can't be 100% sure that he's wrong. But this is a possible discovery violation. I'm just not in a position at this point to say it with certainty.
Well, given Mr. Matheson's testimony that he recognized it and testified to what it was, unless there's some other materiality to it, I'm not going to entertain any further comment on it then until you tell me it's relevant. All right. Let's have the jury. All right, the record should reflect we've been rejoined by all the members of our jury panel. Mr. Gregory Matheson is again on the witness stand, now undergoing a redirect examination. Good afternoon, ladies and gentlemen. Good afternoon, Mr. Matheson. You're reminded you are still under oath, sir. Mr. Goldberg, you may commence your redirect examination.
Thank you, Your Honor. Good afternoon, Mr. Matheson. Hello, ladies and gentlemen. Sir, I wanted to start out by asking you more about this EAP issue, and I know we've discussed it at some length. You were asked about some literature during cross-examination. Do you recall that?
Yes, I do.
And specifically, you were asked about 4 articles that you were shown on the witness stand that you read prior to your testimony in court.
That's correct.
Now, you said at one point that those were the only articles that you considered prior to testifying about this EAP issue for your testimony in this proceeding.
That's correct.
But you alluded to some book that you looked at?
Yes, I did.
Now, why on cross-examination didn't you tell the defense about what was in this book?
I wasn't asked about it. I was limited to the articles.
You mean by the questioning?
Yes, that's correct.
All right. I'd like to get into that in a little while, but first let's take a look at some of these articles that were referred to. Mr. Matheson, first on the Raxall article.
How do you spell that?
W-R-A-X-A-L-L Eames, E-M-E-S.
Thank you.
Thank you. Is this one of the articles, sir, that you considered prior to your testimony?
It's one of the ones I read, yes.
And did this article actually contain a study that was done involving a number of samples to determine how it degrades, how the EAP marker degrades?
Yes, it did.
Now, on these stains that were studied in this particular article, were these stains in a wet condition or in a dry laboratory condition?
I believe they were dry.
Now, the stains at the scene in this case, item 42, if we were to assume hypothetically that when Mr. Fung saw that, he described it as being tacky when he arrived there at some time after 10:15. Would that distinguish the blood that we're talking about in our case from the type of blood that was studied in the Raxall article?
Your Honor, objection states the testimony if he's talking about the fingernails.
I'm sorry?
If he's talking about the fingernails.
Oh. If the blood was tacky or damp, then that would be a different set of conditions.
And when you looked at the bindles on one of the fingernail scrapings in this case, there was some evidence that it was tacky even when it was collected. Is that correct?
There was what appeared to be smearing on it that would indicate that it was still damp.
Now, why is this distinction between damp and dry stains in a laboratory condition? Well, let me ask it another way. Why is a distinction between damp stains at a crime scene as opposed to dry stains in a laboratory setting significant?
Well, it's different conditions.
But what's significant forensically about the different conditions in terms of degradation?
Well, a damp condition, like I mentioned before, hastens certain types of degradation. A dried sample, or even a damp sample for that case that's subjected to heat, is a different type of environmental situation and potentially could create a different type of result.
Now, with respect to the Raxall article, did you, in interpreting that article, take this as a cautionary type statement with respect to the EAP marker.
Overruled.
So I don't,
Did you take this as a statement to a forensic analyst to use caution with the EAP marker in terms of typing it?
this meaning the whole article?
Yes.
Yeah, the crux to that and many of the other articles is just an indication that the EAP has a problem with degradation, and you need to be careful about how it's interpreted.
And is that how you interpreted the article overall?
Yes.
Now, is it correct that with respect to these dried laboratory stains that they were talking about in Raxel and Eames, they did identify a particular degradation route?
Yes, they did.
And I'd like to direct your attention back to our EAP board, so maybe we can understand this. While we're getting that, maybe you can describe for us verbally what this degradation route was that was discussed both during cross-examination and also in Raxel.
My understanding of it is similar to what was discussed before, that under those conditions and identifying the samples the way they are, the process of identifying the types, the degradation route showed the progressive loss of the faster bands or the anodal bands, so that you lose first a A2, B2, A1, and then eventually the B1.
Now, let's take this step by step. You used the term anodal. What does that mean?
That is an electrical term. It refers to the positive side as opposed to the negative side, which is cathodal.
Looking at our EAP phenotype board, the block diagram that we've used, can you tell us which is the anodal side of the diagram?
Looking at the diagram, the anodal side is where the plus is on the left, cathode is on the right where the negative is.
Why don't we take off the little magnetic strips? Okay, so with respect to the BA phenotype, can you describe for us the degradation route that was discussed by Raxel and Eames with respect to dried laboratory stains that were aged?
The degradation route, like previously described on cross.
Maybe you can use a pointer or something so that we can.
All right, and we're referring to People's Exhibit 217.
I believe so. Let me double check.
.217.
Yes.
The degradation route, as was previously described, but using this chart now to show it, would mean that you'd have a loss of the A band, which is indicated above, that's farthest to the left, then the B band, next one to the right of it, then the other A band, second band from the right, and then finally what has been marked as the C band.
And that is the degradation route that was described in this Raxel and Eames.
Yes, under the conditions that they had those samples.
Now, sir, in your experience as a serologist, and also based upon your reading of the literature, is that the only degradation route?
No, it is not.
Okay, and generally speaking, and maybe this is a slight oversimplification, you're saying this particular degradation route would be from the positive side to the negative side of the block diagram that we have.
The one I described earlier, yes.
But it is not the only one.
No.
Your Honor, I'm wondering if I might be able to use the defense exhibit on their block diagram showing the EAP degradation route.
Which item was that?
We don't have it in our system.
Mr. Harris, do you have that available? Do you know which number and letter you want? All right, while we're awaiting that, Mr. Goldberg, do you have any other matters you can take
It
up?
was 1141A through Z.
I think about L is what you're looking for, correct?
It sounds like it might be about
All
right.
right. Do you have anything else you can talk to,
Yes,
ask Mr. Matheson while we're waiting?
yes, I
Mr.
can
Glazer, I
continue.
appreciate your cooperation with that. Proceed.
Thank you, Mr. Harris, too. Now, Mr. Matheson, you were also asked about a article by the name of, by the authors of Zajac, Z-A-J-A-C, Grunbaum, G-R-U-N-B-A-U-M, and Crim, C-R-I-M. Is that correct?
Yes.
And is this an article that came out after the one that we just discussed, the Raxel and Eames article?
I believe so, yes.
And is this the article that previously you testified said that inherent characteristics of the EAP system give rise to the possibility of very serious errors in phenotyping other than fresh blood, especially if the history of the sample is not fully known?
Yes, it is.
Now, in this particular article on page 615,
This is Zajac.
yeah, did they make reference to the Raxel and Eames article that you were asked about on cross-examination that we just discussed?
Yes, I believe it does.
And did they distinguish the Raxel and Eames article as dealing with a different situation from the situation that they were discussing in their article?
Yes.
Can you read for us what they said in order to distinguish Raxel and Eames from their article?
Yes, in referencing the Raxel and Eames article, they followed that up with stating apparently the bloodstains they used were prepared under laboratory conditions and the history and drying and preservation were well known.
And in Grunbaum, were they trying to give an idea of what would happen to wet samples that were not prepared under laboratory conditions?
It's bleeding.
Well, in the article, what did they say? What kind of stains were they dealing with here?
Okay, the comment they made is that the preparation of their blood samples were done in such a way to simulate the adverse conditions which may take place in actual casework submitted to a crime lab.
Now, with respect to their article, did they identify the same degradation route that you just described that was discussed in the Raxel and Eames?
I don't believe it was specifically delineated there.
Okay. Did they say that, how did they characterize, can you read for us how they characterized the problems of misidentification that occurred in this particular study with the samples that they created?
It states the problem with misidentification of the samples in this study was not due to weak or indistinct band patterns. Rather, discrete bands were present and readable, but they had been altered to indicate erroneous phenotypes.
Okay, and How did you interpret that, Mr. Matheson?
Well, again, that this system has degradation problems, and that multiple bands can be read still and misinterpreted.
I mean, even if you have discrete band patterns, such as 2B bands.
I believe that indicates that.
Now, could I see 1141G, Mr. Harris? Is that possible? And then I want to see H and I. Okay, I want to go back to the Raxel and Eames article and the degradation route that they discussed. What does this represent when we're looking at the BA block diagram?
It represents a general location of the bands of a type BA.
All right, and the B block diagram?
It also represents the general location of the bands of a type B, though in neither case does it give any sort of indication of the intensity differences.
And then let's see, this is H. Can we see U? When you said that they don't give an indication of the intensity differences, you mean what?
Well, that's one of the ways of determining the types is, particularly between a B and a C, is how intense certain bands are. And these are just all being blocked as approximately the same size, as opposed to the People's Chart on EAP, which does define the different intensities by the different sizes of the bands.
Okay, now, can you tell us what we're looking at here in terms of the degradation route?
This is consistent with the degradation route described in the Raxel article.
And that is what?
That you lose the bands from the anodal side or the plus side towards the cathodal side or the negative side, the slow side.
Can you orient this just verbally in relationship to the People's Chart, the 6 EAP diagrams on the block diagram, just to show us how the two would interrelate?
If you, excuse me, if you were to turn the chart that's being projected up, be 90 degrees to the left, so that the arrow would indicate the origin or the cathodic side.
Okay. And can we see the next, it would be V on this, please? And now what does this show?
See, it's the final step in the degradation route that's described in the Raxel article, where what originally started out as a BA, the only thing that's left is the B1 band.
Okay, but you're saying that this degradation route that you were asked about is not the only one that you have seen or that is in the literature?
That's correct.
1141, is this V? V is in Victor. The previous one was 1141U.
Okay, thank you. Thank you, Mr. Harris. Now, the another one of the articles, the 3 articles that you were asked about, was the Yashan. Excuse me. Let me ask you about the Sensiba article first. Did the Sensiba article contain a broad-based study of the phenomena of EAP disintegration, or were they looking at only one stain when they discussed this degradation route, the one that we just saw in the defense?
It appears by reading that article that when they're referencing that degradation route that's been described in the Raxel article, that just two bloodstains were used, one of a type B and one of a type BA.
All right. And then finally, the Yashan article that was referenced. Did the Yashan article contain what purported to be a study of the phenomena of BA disintegration to B?
No, it did not.
What was that?
It was a technical note regarding the degradation of a B to a CB. I don't know if it then carried on to a C, but the A allele was not mentioned.
Okay, so Yashan was not actually studying, did not purport to be studying the BA to B phenomena per se.
That's correct.
She was studying other issues in the EAP marker system with respect to degradation.
Oh, I don't know about studying. She was referencing other issues, yes.
Now, with respect to all four of the articles we've mentioned so far, the Raxel and Eames, the Grunbaum and Zajac, the Sensabaugh, and the Yashan article, considered together, did you take those articles as some sort of a cautionary statement to the forensic analyst with respect to the EAP system?
Yes, I did.
How so?
And that is, I mean, every one of them indicates that the EAP enzyme, unlike the other ones, does in fact degrade, and that a degradation can lead to mistyping. So you have to be careful about how you interpret EAP results.
Now, when you were asked about the Raxel and Eames, well, let me ask you another question first. This book that you alluded to during your direct examination, what was the book?
It's the Forensic Science Handbook by Richard Saferstein.
And was there a particular portion of that book that you referenced in particular informing the opinions that you expressed on the witness stand with respect to the BA to B phenomena?
It enforced my knowledge of that, yes.
Can you tell us which portion you looked at?
It was a section that was written by Dr. Sensabaugh.
Maybe you can give us the page number, because I believe counsel may have a copy of that.
Well, it's chapter 8 that starts on page 338. The area that we are referencing, I believe the paragraph starts on 369 and concludes on 370.
You have that, Mr. Blazier?
If I may look for a minute.
Excuse me.
Mr. Goldberg.
And did Raxel, did Mr. Sensabaum in this chapter that he authored mention the Raxel and Eames, or what we've discussed as being the Raxel and Eames degradation route?
Yes, it does.
Did he say that that was the only degradation route?
I don't believe so, no.
Can you tell us what he said?
Well, it makes reference to the stabilities of the isozymes. They're the different types. One quote here is that the A isozymes are the least stable and the C isozymes the most stable. Thus, one might expect the A bands in BA and CA types to be lost before the B or C bands are lost, and this in fact has been observed.
And does he say anything?
I'm to object unless the rest of that paragraph is read.
Mr. Goldberg?
I don't know what the legal basis of the objection is.
I think it's 256.
What?
256, I believe.
Sir, can you read the rest of the paragraph?
Be happy to.
Sure.
In typing aged type BA bloodstains, for example, only the major B band, the anodal band, may be apparent, and the temptation would be to type the sample as a B. To avoid error of this sort, empirical rules for typing interpretation need to be invoked. Since it has been observed that in aged BA bloodstains, the slow B band is generally lost before the fast A band, the controlling rule is to withhold judgment on a putative B type until both B bands are apparent. If the sample is in fact a BA type, the major A band should be apparent by that time.
Now, did Mr. Sensabaum identify any particular degradation route that is different from the Raxel and Eames degradation route?
I feel that this article, or this paragraph, actually mentions a couple of different routes or discrepancies between the possible ways the degradation can occur.
Objection, move to strike as non-responsive.
How so? What other degradation route is identified there, sir?
Well, in one sentence, he states that in typing age-type BA bloodstains, for example, only the major B band or the anodal B band, this is the anodal or the one closest to the anode side, as opposed to this band, which is a cathodal or closest to the origin, may be apparent. He's saying that at some point it's possible that only the major band or the brightest band might be present.
And how is that different from the Raxel and Eames?
In their study, they saw the degradation route so that the cathodal band was the last one that was apparent.
Maybe we can let's just cover up the A bands for a moment so that we can make sure that I'm understanding. Yes. In the BA, on the BA chart for the record, I just put the covers back over the A bands on the BA phenotype. Okay,
Yes.
so according to the Raxel and Eames study, they're saying that which band would remain after the sample had degraded?
The most cathodal one, or the one closest to the origin.
Okay, the one that's on the right side of this diagram.
That's correct.
And in this portion that you just read to us in Sensabaum, he's saying which?
In that one portion there, he makes reference to what he calls the major B band, or the cathodal B band, or the anodal B band may be apparent.
And does he say that these degradation routes, that it always occurs in either of these two ways?
I didn't read that in there, no.
Does he say that, that these are general ways that they happen, that this is how it generally happens?
There is the term generally used. Yes.
So in interpreting that, did you, as a forensic analyst, take that to mean that this is the only path, degradation path, that this marker will take, or that this is one of the degradation paths that this marker will take?
Objection, leading.
Sustain. Rephrase the question.
How did you take that term that this generally can take these two paths?
On reading that paragraph and the discrepancies between the different types, it indicates to me that there may be more than one way that degradation can occur.
And did you take the totality of the articles and the book that you just referenced, and also the source book that I think you referenced earlier in your cross-examination, as providing some sort of cautionary statement to the forensic analyst when trying to type a B and distinguishing it from a BA?
Yes.
And what was that?
Again, in general, that this is an enzyme that has degradation problems, and you just have to be careful about the interpretation of the results.
Did anything that you read in these articles, Mr. Matheson, cause you to change the statement that you made initially on your analyzed evidence report that you could not exclude the possibility that with respect to the fingernail scrapings, it was a BA that degraded into a B?
No, it did not.
Did anything that was brought up during cross-examination by the defense cause you to change the opinion that you've offered on direct, that probably the samples underneath the fingernails were a BA that degraded to appear to be a B?
I'm not sure about the term.
Objection, misstates the testimony.
Sustained.
Okay. What was your opinion, your bottom line opinion, when you considered all of the facts of this case as you are aware of them, including the photographs of where the victim's body was, the pool of blood, item number 42, and the other tests that you did? What was your opinion as to the fingernail scrapings?
Well, the result does not change. I did see a B, but in considering absolutely everything, I would have to say that it is a likelihood that the blood that was found under the fingernails were in fact from Ms. Brown and had degraded. But again, I cannot totally eliminate the possibility that it's a B.
Okay. Now, did anything that was brought up during cross-examination cause you to change that opinion or reevaluate that?
No, it did not.
Now, sir, with respect to resolving this issue, is it possible to look at a control study from the scene?
I don't know if it totally resolves it, but it does lend credence to the possibility that you have degradation occurring.
And what does that mean, using a control study?
If you are typing, or if you test another blood sample that's of a known source or that you believe to be of a known source from the scene, and it shows a similar type of degradation that you have seen in the past and experienced, and that possibility exists in your sample, then I believe it's important to take that into consideration.
Now, is this idea of looking at a control study, such as a pool of blood underneath the victim, something that was reflected in science, in forensic science literature, that you considered prior to your testimony here?
Well, I had that opinion prior to this. However, I have read an article that enforces my opinion about that.
I had it right in my hand. Okay. Specifically, sir, did you look at an article by Bruce Berdoli and Robert Allen entitled Electrophoresis Reliability, the Contaminant Issue?
Yes, I did.
And
Direct your attention to page 1546.
Mr. Blazer, do you have that article?
We cited this in one of our papers, Your Honor. Sir, is this dealing with the EAP issue per se, or is this dealing more broadly with various contaminant issues in electrophoresis and problem resolving in electrophoresis?
It's dealing with electrophoresis reliability in general, not just with EAP.
Can you tell us, can you read for us the portion of the Berdoli article that suggests looking at a control study from the scene and trying to provide more information about what's happening at the scene? The portion that I have bracketed off there.
Starts with, furthermore, the competent and experienced forensic scientist does not work in a vacuum. It should be stressed that the analyst gathers as much information as possible regarding the case, then in parentheses, and potential influence such as contaminants, close parentheses, to evaluate properly the data obtained from evidentiary material. More importantly, in reality, an ideal control study is naturally provided to forensic scientists. This is the electrophoretic analysis of victims' blood on victims' clothing and other substrata. The blood shed by a victim onto his or her own clothing and surrounding substrata is exposed to the same myriad of environmental insults as other questioned stains submitted to the laboratory for electrophoretic analysis. The accuracy of electrophoretic typing of the question sample can be independently verified with the victim's whole blood.
And sir, what was your interpretation of that in terms of using a control study to resolve issues as to what's happening in a crime scene?
Well, that confirmed a policy that we have had as far as collecting a known blood sample from the scene from each of the victims, and that information from that can be used to consider information derived from other samples.
And sir, is that why, in expressing certain opinions in court on direct examination regarding this EAP issue, you considered test results on the pool of blood underneath Nicole Brown, item 42?
Yes, that's correct.
Maybe we can see the serology results for it. Now, Mr. Matheson, when you considered those test results on 42, were those test results inconclusive?
Yes, they were.
And were you reporting those test results? Let me wait until we put the board up. Maybe it will make it a little easier. That's People's 202. Okay, directing your attention to the item that says 42, blood under Nicole Brown. Under the EAP column, it says inconclusive B, very weak. Is that correct?
Yes, it does.
And were you reporting this inconclusive result for the purposes of suggesting that it was correct? In other words, that the blood was in fact a type B blood?
Well, I did not report a type at all for that. My report reflects inconclusive.
I'm sorry, my terminology was wrong. When you were testifying about this result, were you testifying about it for the purposes of suggesting that the inconclusive B was a correct result in the sense that the blood really was a type B?
No, I was not.
So what was your purpose in considering this and testifying about this and giving your explanations about the EAP results under the fingernails?
Okay, the inconclusive, like I mentioned, no activity would be you're not seeing anything on the gel. A result that's reported is a definitive result. It's what you are seeing occurring on that gel. A inconclusive falls somewhere in between. It's a pretty broad range. It could be just almost possible to call, but you're not quite sure there's something about it, or it could be something that's very vague, just kind of a blurry occurrence in there. In this case, I observed what I thought might be a B. It wasn't good enough to call. I am not going to say for a fact that it is a B, but it occurred in an area and on a sample that we are assuming to be from a particular person and thus of a particular type. We know her for a fact to be a type BA, and the fact that this is an inconclusive B shows that there's something going on with this blood and with the samples, and that the results should be interpreted carefully.
Your Honor, at this time I'd like to mark two more exhibits, and they're similar to, in fact, just smaller versions of the ones that the defense marked. As people's next in order.
224.
And I mark them as 224A and 224B.
Yes.
And A is what appears to be an electrophoretic, and it has the numbers 1304.
And Mr. Blazier, you're familiar with both of these?
And 224B is 13, excuse me, 7-3-10.
All right.
Now,
Would you show those to Mr. Blazier real quick?
when you were talking about item number 42, just a few moments ago, what is the purpose of collecting that item again?
I think we've asked this a couple times.
Okay. So, sir, when you were saying that you were assuming that that is the victim's blood, that's based on what?
The location from where it was collected.
Okay. And is that why this type of sample is collected?
Yes.
Sir, I'd now like to show you People's 224A and 224B. Showing you 224A first. What is that?
224A is a copy of a photograph of my electrophoresis run number 7309, which contains, among other items, the fingernail scrapings 84A and 84B.
Okay, and 224B is?
224B is another photograph of electrophoresis run number 7310, which includes, among other things, the results of item number 42.
Now, on 224B, for identification, I'd like to, perhaps, if I could put it on the Elmo and then maybe pass it around, but I'd like the witness to write something on it first. Could you identify for us, just by writing on the bottom of the photograph, where 42 is?
It's in position 4, putting a arrow up from the bottom above the number 42.
Now putting 224B on the Elmo. Can we see the part of the photograph that has the writing on it? No, we need to see the white part, the bottom. Okay, so have you written in where 42 is?
Yes, I have.
And is one of the reasons that you considered this that logically a pool of the victim's blood should contain the victim's blood?
Yes.
So without testing it, would have you expected this to look like a BA?
Yes, I would have.
But when you tested it, what did it look like?
Well, gave a weak result that eventually ended up being called inconclusive, but I saw the two B bands very, very lightly, kind of fuzzy clouds in the areas where you'd expect to see them.
Maybe we can just, with directing the arrows, print out where those are.
Oh, okay, we need to go up. Move the arrow to the left. Now to the right. It can go lay right on top of that other band. And that's pointing right into the lower V-band. That's fine right there.
Okay, and let's put another arrow on the upper, pointing to the upper B band.
If you go directly above the arrow that was previously placed by 2 bands, go up, 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 down a little bit. Right about in there is the other B-band.
I know it's hard to see on the Elmo, Mr. Matheson, but when you look at this plate, do you see any distinct band pattern in either of the 2A regions?
For that item?
Yes.
No, I do not.
But do you see a band pattern in the 2B regions?
I see something that has kind of a band-like appearance. It's not a good band. If it was, I'd have called it.
All right. Now, assuming this is in fact a BA, using the Raxel and Eames degradation route, if we assume that were the only degradation route, would you expect to see this?
No, I would not.
Why not?
Because if this is a fact, a BA, as you're assuming, then I would expect to still see that lower A band in addition to the 2 B bands.
Here, I'm going to object. This mischaracterizes this exhibit. I see a band there.
Overruled.
Now, Mr. Matheson, by the way, how many years do you have of experience in total looking at these banding patterns?
Approximately 12 years.
And you're saying that there are only 2 distinct, I'm sorry, they didn't say they were distinct, but there are only 2 band-like patterns that you see on this.
Objection. Mischaracterizes testimony. He said it was not a band.
Sustain. Rephrase the question.
There were only 2 patterns that you saw, is that correct?
In that lane, I am seeing what appears to be 2 very weak band-like appearances in those areas. This is a very weak sample, difficult to read.
Now, can we print this out? As People's 224.
C.
Now, with the court's permission, could we show this to the jury, because the resolution on our Elmo isn't that great.
Yes.
And just before I show them to Mr. Matheson, so that we know what we're looking for, you wrote a 42 on the lane that represents 42. Is that correct?
Yes, I did.
Pointing up. And the, well, maybe we can also pass around the printout too, so that they can just compare.
May I see that, please?
Sure.
I would object. Right now. Passed around. I have no objection to the photograph.
Well, I just think the printout might be helpful in identifying where to look.
I disagree. I disagree.
All right. Objections overruled.
Still waiting.
That's correct, John. One more to go.
Okay.
Your Honor, perhaps with the court's permission, I might be able to ask a couple questions.
Please do.
Just to, yeah, thank you.
I'd like to finish with Mr. Matheson today if we could.
Your Honor, I'd like to mark as people's next in order. 225, and I may also be marking the 224D later on. but as 225, a document that says electrophoresis worksheet.
And Mr. Blazer, you have a
And
copy of this?
contains 41, 42, it's L387.
All right.
Mr. Matheson, while we're waiting for the printout, can you just tell us what L387 is?
L387 is a photocopy that actually is slightly crooked, cuts off part of the left-hand column of one of my electrophoresis worksheets that corresponds with photo number 7310.
And on this particular worksheet, you called item number 84, the fingernails, as a B what?
This worksheet does not have 84 on it.
That doesn't have 84. Does that have 42 on it?
Yes, it
I'm
does.
sorry. And what was 42 called as?
A B question mark INC for inconclusive. The second reading on that was an NA for no activity.
I just want to perhaps put this on the Elmo just one more time, if I may, before I go to the jury. This is 224B. I'm not going to mark it or make another printout.
We have to see it again?
I just want to make sure that everyone knows where to mark.
I think the arrow there is apparent in the lane.
Okay. Now, sir, between in the arrow is pointing to an area that, I guess on the photograph would be about a quarter to a half of an inch above it, that's sort of a bright band. And where is the band that we're looking for in relationship to that?
Well, it's in that same,
Mischaracterizes the testimony.
Sustained.
What?
Band.
Well, I'm referring to you see these very, very bright hash marks that go all the way across the bottom part of the photograph.
oh, I'm sorry, yes, I do.
Okay. And there's one of those hash marks, there's an arrow that has number 42, and the arrow is pointing to one of the hash marks.
Yes.
Okay, where in relationship to that hash mark is the lane that constitutes 42?
42 is everything directly above the arrow. It's a lane about 3/8 of an inch wide, directly above the arrow.
I'm sure hash marks probably wasn't the scientifically correct term, but
Mrs. Robertson?
No. Collect that from Deputy Long, please. All right, proceed.
Now, Mr. Matheson, I want to show you 224A for identification. And does that, do you still have that? Does that have item number 42, excuse me, item number 84 in it?
Yes, yes, it does.
And using the same pen, can you write arrows for 84A and 84B?
Okay, I'm writing an arrow, two arrows, down from the two columns that indicate 84A and 84B, and then marking 84A under one of the arrows and just B under the other one because of lack of space.
Sir, on that, are there any other results that you got that appear to contain a B-like pattern?
There are actually a couple others that I called B inconclusive, and I believe there is one. No, that's it.
Is there a 117 on there?
One of the lanes is the results of item 117.
Can you
yes.
just point that out for us with the arrow, in other words, and write 117?
Okay, I'm writing, again, an arrow pointing up into the lane that expresses the results or the data obtained from item number 117.
And was 117 identified as being one of the rear gate stains from the Bundy location?
Yes, I believe it was.
And you got a B-like pattern on that?
I called it a B question mark inconclusive, yes.
Now, Mr. Matheson, why do the lanes that contain 84A and B look so messy to a layperson?
Well, there are times in electrophoresis where when you're doing a run, there is something that blocks or hinders the electrical flow through it. through the gel from one side to another and causes the bands not to migrate as evenly as they should.
Now, with respect to 84A and B, are there any hazy areas on this that do not, in your opinion, constitute a distinct band pattern?
Well, there's general haziness in a lot of the areas.
And maybe using the marker, you can identify some of the haziness for us that, in your opinion, does not constitute a distinct band pattern. In other words, an A-like band.
Well, in general, there is a haziness that shows up. We're talking about 84 and 80.
Carrie Bonnie, and at this point in time, we are going to be ending the stream, and thank you all for coming out and hanging out with us tonight. We'll see you on the next one, and peace.